Good morning, good morning, good morning, amazing Law Nerd. We're streaming. It's Tuesday, April 14th. Replay crew, don't forget all the timestamps are down below so you can see what you want to see most. We try to make them informative without making them spoilery, and sometimes it's really hard when we're talking about court, but today we have quite a lot to talk about. We have 2 trips on EDB Air. I think we're going to get lots of miles because we got to get to Utah. And then we need to get to Massachusetts. Why? Well, we have some filings from yesterday. And so at the end of the night, I was like, you know what? Let me just take a peek. Let me just take a peek in Utah. And I was like, that's a brand new filing at the end of the day yesterday in Utah from Kouri Richins attorneys. And then I saw the title of the filing and went, of course you did. So we're going to do that first. I didn't read the rest of it. I was like, of course you did. Of course you did. So we're going to go to Utah first, then we're going to go to Massachusetts. We're probably going to be staying over in Massachusetts for tomorrow as well. We have a lot to cover. So we are just getting ready for all the things. For those of you who asked, yes, there is more purple at the bottom of the hair. There is more purple at the bottom of the hair. It's easier to see outside. It's less easy to see in the studio lights, but yes, there is purple at the bottom of the hair. We got a haircut. We needed a haircut. We very much needed a haircut. So yeah, we're gonna EDB Air to Utah. We're gonna EDB Air to Massachusetts. We might stay the night in Massachusetts together. It's great. We'll have some lobster rolls. It'll be a wicked pisser. Wait, that might mean raining. That might mean hanging out and drinking. I'm not sure which one. We're going to have a good time either way. So are you guys ready? Buckle up. Let me know where you're coming in from, what you're drinking. I have water. I have coffee. I apparently have cat hair. It's a Tuesday. Feels like a Monday. We were so busy yesterday. Yesterday was such a busy day, but we're working on exciting stuff for the Law Nerds, and it's really difficult. As an ADHD human, a human who has ADHD, it is so hard for me to go from an idea to not immediately being able to talk about it and have it do the things. But Team Baker has been very, very patient with me when I'm just like, I want it now. And, I can't bippity boppity boop things into existence. So we have some very exciting things coming for you. We were talking about them yesterday, and I'm so excited. I'm so excited. I'm so excited. We have so much going on. So let's go to Utah for the audacity, and then we will go to Massachusetts. Today, we are dealing with Karen Reed's mostly federal case. We haven't talked about the federal case in a minute. But we're going to talk about the federal case. We'll do a brief road so far. We're going to talk about the Proctor stuff. We're going to jump into Proctor problems first, because honestly, the audacity, I can't. If there's Proctor problems, we're just jumping to that. And also there's more Proctor phone problems. So we've got a proctory type of a conversation in Massachusetts, but then there's other stuff going on in the civil case in state court. We'll get to that probably tomorrow. So that's where we're at. For those of you who are like, there's a federal case and a state case. Yes, don't worry. We'll do the things. I'll get you all caught up. But first, Kouri Richins. Girl. Let's roll the intro. Let's go to Utah. Let's go. Let's see if we can do both. Utah, give me 2. Let's go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. I think we then just fly. I think that's what we just fly, right? We just fly. Yeah, we do. So one of the big questions we all had in the Kouri Richins case after the verdict came down, first of all, I guess my first question was, wow, that was fast. But after we saw interviews with the jurors, we were like, hey, these jurors were incredibly diligent. They took a lot of notes. They went in. There's only 8. They don't have 12 in Utah for the crime that she was charged with. They only have 12 if it is a capital punishment case. So 8 people chatted it out, took a vote, convictions. They were mindful. They didn't just tick every box yes, which I know is sometimes what we're concerned about. Like if a jury comes back too fast and didn't even think about it, you're like, ooh, is that going to be a problem? No, they took copious notes. They were incredibly diligent and they came back with a verdict. They said it felt like longer, but they came back with a verdict in like 3 hours. Felt quick to me, but they were paying attention. So kudos to a smart jury. We love it. And after that, they set the sentencing date, same. Like verdicts in Kouri is like, not wailing like Donna Adelson, but she is, head down and stoic. And then the court's like, okay, now we need to look at the calendar and remember how it felt like this case was coming to a screeching halt because there was still like 2+ weeks of court time slotted for the defense case. And then all of a sudden it was like, and done, closing arguments. So the fact that closing arguments maybe felt a little disjointed from the defense, I just wonder if they were not anticipating doing closing so quickly, but they had a whole weekend. The prosecution was like, we're ready to go. Let's be done. So as they come up with the sentencing date, it seemed to me that Judge M's looking at his calendar and he had asked for, sorry, when there are spoilers in the chat, we just got to kick them. He was looking at his calendar and was just like, oh, I've got this date, this date, this date. And I think the reason that the court was just looking at calendar dates is because there was such a long span of time that the court was just accommodating this trial that the court didn't have a lot of open dates. And let me tell you how that goes in court. When a judge is going to be in a trial that is going to be this long, every other case that comes before the court's like, okay, can we set that on this next date? I won't be in trial. And the court leaves like snippets of time in case there is something that statutorily has to be addressed. But oftentimes when a court's in a long cause case like that, the statutory issues like anything dealing with bail or bond or whatever will go to a different judge. And we know there aren't a ton in Summit County, but the court does the best they can to, in trial time to move the trial along faster. And so other cases get shuffled around. And if there's no statutory issue with bumping it back a little later, the court starts piling up their calendar after the trial date. So when the court's like, hey, we don't have a ton of time here to sentence, it's because the court schedule, like imagine you go to schedule something and they're like, okay, well, this whole month and a half is blocked off. Every other case gets put over till after that. And as every other case is getting put out on till after that, you have tons and tons of time that is just blocked out. And the court gave two options because, of course, you also need time to get the interviews done and to prepare everything for sentencing. Because this sentence, and at conviction, I was like, oh, this is like this. It's going to be, it's a non-death penalty capital case. It's just going to be 25 to life. Incorrect on my part. The judge, I figured the sentencing was about the other cases, but no, the judge has discretion between, I thought it was automatic LWOP on a special circ or aggravated case with no capital punishment. I was like, oh, it's just going to be an LWOP case. Nope. So then we get to, it could either be life without parole or 25 to life, and they need to do a probation parole report. And so they need at least, I think, 30 plus days to do that. And then they need a sentencing date, and the court's calendar was busy. So long and short of it is they needed at least 30 days, but they didn't want it to go out too far. They also need days that can be accommodated by the victim's family. And they ended up picking a sentencing date that to us, we immediately went, wait a second. Isn't that the victim's birthday? I don't think the court even put the two together. I imagine that the court was still buffering on everything that happened during trial and closing arguments and if the jury instructions were right and all the rest. I don't know if the defense clocked it. We clocked it. I'm sure that the victim's family clocked it. And I don't think they were upset about it. But as of last night, Miss Kouri Richins would like a different date. Yeah. She would like a different sentencing date. She would like to move the sentencing date a month. And again, this was filed late in the day yesterday. I will check before the end of the stream to see if the prosecution has responded. Motion to continue sentencing. Kouri Richins, by and through her counsel, moves this court to continue sentencing from May 13th to the week of June 15th based on the following. Because we want to, Your Honor. Considering the seriousness of the sentencing options, either 25 years to life or life without the possibility of parole, additional time is needed to properly research and prepare mitigation evidence and witnesses for Ms. Richins. What mitigation witnesses? She didn't really mean it. When Bloodworth was saying she wanted him good and dead, that's not true, that it was all just jokes. What mitigation? Her mom and her brother? In order to present mitigation evidence and to allow family and others to address the court, the defense would request that the matter be scheduled for a full day. And that argument might be the thing that allows the court to move this case. Because right now it is set for an afternoon. And it might need to be set for a full day. And if it needs to be set for a full day, which is what I think is probably right, the court is going to have to find another full day on calendar. And if the defense is saying, we don't have enough time on that date, well, then we end up with the court saying the defense has a right to present what they want to present at sentencing. And if there's not enough time, then we need to accommodate more time. I'm interested to see if the prosecution responds if this date is inconvenient for the victim's family, because that is a consideration to not pick this date. Could that go to another date in May? Sure. Could that go to another date in June? Sure. Could that go to a date in July? Sure. So let's see what footnote 1 says before we get to the other points of the motion. But Your Honor, we need more time. Holly Jolly in the chat said, why do we need to hear from Kouri's family? Well, we don't. But when I'm guessing who's going to speak in mitigation for her, that's my guess of who's going to speak in mitigation for her. Would be her family members. That would be my guess. Maybe some of her friends, but the defense has a right to present mitigation, especially when the court has the option between two sentences and very different options. Footnote 1. Pursuant to the Utah Rules of Criminal Procedure, Rule 22, the court must afford the defendant an opportunity to make a statement and to present any information in mitigation of punishment. Right, like I said, if the defense says they need more time to prevent this from going forward on the victim's birthday, to present information, the court is going to have to find a full day. If they show up and then present no witnesses, I am going to absolutely holler. Absolute hollering. Northwest said maybe a mental health evaluation to mitigate. That's part of the evaluation that they already have a PSR for. So that'll happen already. So they shouldn't need more time for that. They're not asking for more time for a PSR. The PSR is already underway. They're asking for more time for witnesses. McKenna said, oh, you know that's going to happen, EDB. And again, they could say we need more time to prepare mitigation witnesses and then change their mind. They're the defense. They have the right to do that. I think they just want to move this date off of the victim's birthday, which I can understand. But honestly, I don't think that's going to sway Judge M. I don't think that the date is symbolic to the family, but I don't think it's going to sway Judge M. It's not like he's going to choose to LWOP somebody because of the date on the calendar. He's a much more conscientious judge than that. And I just can't imagine that being the thing. But I can also understand where they're just like, well, we need to do this. They go on to say in the footnote, see also State v. Costello, which holds that a sentencing court is to consider all evidence before it, the totality of the circumstances, in imposing sentence, in determining the sentence in the case of aggravated murder. Furthermore, there is no presumption in favor of either of the two sentencing options. They're like, Your Honor, this is up in the air. It's not very up in the air for me, but it's up in the air for them. In order to present mitigation evidence and to allow family and others to address the court, the defense would request that the matter be scheduled for a full day. Ms. Nestor has very recently had a death in the family. I'm sorry, Ms. Nestor. That is truly awful. I hope that your family is well, and that's hard, and will not be available to adequately prepare for the May 13th hearing. Well, the judge is going to grant that. Yeah, that's a reason to grant it. Oh, further, she's currently scheduled to be out of the country for the first 2 weeks of June. So could you do the end of May before you go out of the country? Like, a death in the family is a legitimate reason to postpone something, because lawyers have lives. I think I've told you the story of me being yelled at in court by needing to help with a death. And the judge being like, and I'm like, fine, hold me in contempt, I'm leaving. Like, I've given you a heads up. The defense is fine. The defense is fine continuing it. There are no witnesses. It's a post-sentencing motion. Hold me in contempt, then I'm leaving. Fine. But a death in the family is a reason to give counsel a little bit more time. But I would imagine they can just pop that in at the end of May before she goes out of town. So she's currently scheduled to be out of the country for the first 2 weeks in June. Mr. Ramos is scheduled to be in trial the week of May 11th through the 15th, and is unavailable on May 13th. That's not necessarily a reason to continue it, that Ramos is in trial. They have 3 attorneys. They don't need all 3 at sentencing. You need at least 1 at sentencing. You don't need all 3. But, it is what it is. And Kouri does have the right to have her lawyers there. So didn't Ramos know he was supposed to be in trial? Maybe not. Maybe it just kicked over. But I don't know if that's the end all be all for trial, that Ramos isn't there. I would love to see what suit he chooses to wear, but it is what it is. For reasons stated herein, Ms. Richins respectfully requests the court to continue the sentencing hearing to the week of June 15th. I imagine if the prosecution responds, that the response is going to be, these dates work better for us. Having a death in the family is a reason to bump it back. But if Ramos, let's just look at a calendar. This is where I'm at. If Ramos is, by the way, for any of you who have studied for the LSAT, the LawSat. If any of you have studied for the LawSat and have seen all those puzzle questions, they don't tell you the truth. Let me tell you the truth. The reason you have to do all those puzzle questions is to figure out fucking case calendaring. Okay? Case calendaring is one of the single most difficult things, depending on how many attorneys you have, because you've got a court calendar that you need. And then you've got, if defense attorney A is available on this date, but defense attorney B is not available on this date, and this date, and defense attorney C is available on this date and this date, but not that date, to also include this date, and prosecutor A is available on this date and this date, but witness 3 is not available till this date. What date can everyone be in court? That is why you have to do all the scheduling problems, because the logic games are just calendaring. They removed the puzzle section. They removed the puzzle section? No wonder there are so many calendaring issues. Well, I mean, not these attorneys. These attorneys all took the LSAT many moons ago, but you need the puzzle. I have thoughts. You need the puzzle section. The logic games are so necessary. No, the logic games are the best. The logic games let you know if lawyering might be for you. I hate that they removed it. Either way, calendaring. Let's take a look at the calendar, not mine, but a calendar because dates are a thing. So if Ramos is in trial till the 15th and Nestor is gone the first week of June, that means the week of May 18th and May 25th are open. Okay, but hear me out. The week of May 18th is real bad for me. The 25th is Memorial Day. So maybe like the 27th. Maybe. Maybe. Also, isn't DCI kickoff like June 26th? Okay, that doesn't work either. So we need to avoid June 26th. We need to avoid like May 21st, 22nd. And then you've also got to take into account if the judge's kids are getting out of school, what the school schedules look like, what the prosecutor's schedules look like, what the family's schedules look like, if the victim's family has travel plans, all of that mess. Okay, well, good times with the motion to continue. Let me just check. I said I was going to do it at the end of the stream. Maybe we'll just do it both. I'm just going to double check the calendar and see. I mean, it's still pretty early West Coast, and see if anything else was filed because I'm curious. What do you think? Should we just side quest and then just fly to Massachusetts? For all of you that were on the BTS of the podcast recording, my ability to talk has continued to not improve today. There is too much going on. That's what it is. All right, let's just check I'll check it again right before we leave, but we'll side quest and check it now. I imagine that the prosecutor, after getting this filed kind of late in the day yesterday, will then need to check in with all of the victim family members and make sure that there are days available for them. And that can take some time. So especially since I'm sure this will start getting reported this morning. So even if the family didn't hear it from the prosecutors, they will probably see it because of when it got filed yesterday, it'll start to be talked about today. Though I was tempted to like make a Instagram post about it last night and be like, haha. But then I was like, no, we'll just wait for stream. We'll wait for stream. We'll just wait for stream. And I know my calendar doesn't count in sentencing. I'm just putting it out into the universe because you never know. Fortuitous days, it might just work. We'll make it work. We'll make it work. Not on DCI kick. I shouldn't say that out loud. I don't think the defense would be like, yes, let's do it on DCI kickoff day. I don't think that they would. But one never knows. One never knows. All right. While the slowest docket in the world is being pulled up, the defense wants a new sentencing date, I think not based on the seriousness of the allegations, based on the defense saying that they need a full day and that the defense attorney has had a death in the family. I think on those two things, Judge M will be willing to move the sentencing date as long as the victim's family can attend on that date. He will make sure that that is a date that the victim's family can attend, and that will kind of take priority because Kouri's not going anywhere. At the end of the day, what does it matter? I mean, all of us are like, we're ready for the final entry of judgment. We are emotionally ready to like just done. But she's not getting out of custody. Her being sentenced between May and June really doesn't change all that much. And the reasons that they have cited are valid reasons to move the sentencing date, annoying though they may be to me. So we'll see. But I think that the judge, once the judge has feedback on what dates work for the victim's family, I think the judge will move it. So tentatively, the sentencing date for Kouri Richins will likely move. I am annoyed. I was ready for like Banfield, then Richins. We had the beginning of May planned out. But look, these are other people's court dates. Other people's dockets. We're not in charge. I think that either way, we're just gonna wait for the sentencing. Tasha said, could it be May 8th? Perhaps. They're not gonna bump it forward. That's when the defense is like, we need more time. They're not gonna bump it forward. And we talked about how calendars get backed up with court. With calendars getting backed up with court, it might take a little time to find a full day that the court actually has a full day to set aside for the sentencing. I think a full day for the sentencing is appropriate. So I think that the court will change the date based on what the defense has requested. The court's going to make sure that date works for the victim's family. And then the court's going to have to find a date that they have a full day available, or at least a full day, 10 a.m. to 4, or 10 a.m. to 3, and not take a court break for lunch if they can. So with all of that, it looks like the sentencing for Kouri Richins will probably move. Now, the court hasn't ruled yet. No final decision has been made. But based on the defense representations and based on the fact that they need more time on the sentencing day, I think that the court will probably accommodate that at the end of the day. The rights are the defendants. Of course, the judge will make sure that the victim's family can attend that day, but the rights are the defendants. And if the defense says we need to present more witnesses and we need more time, the court will give it to them. And there is a choice of sentencing here between life without parole and 25 to life, plus a sentencing on the other dates. And if the defense wants more time to try to mitigate that, they can. Now, they might not be able to mitigate that, but they have the opportunity to try. So we're going to see the court date for sentencing probably move. I am keeping an eye on the dates in the civil cases. Remember, Kouri has 30 days to find new lawyers in the civil cases or represent herself. And the trailing case, I have cat fuzz. The trailing case for the financial crimes was also set on the sentencing date. So that will probably just get moved to whatever sentencing date this gets moved to. So I imagine the financial crimes will also bump. They're going to need new attorneys on that case. So it's just going to all shift. So tentatively keep an eye on your calendars. I will keep you up to date when the prosecution responds. I imagine the response will be, if we need a full day, we need a full day. These are the dates that the victim's family is available. And then the court will pick it. I think that there's a possibility that Kouri Richins will have something to say at sentencing. I think that's a very real possibility. Even with the financial cases pending, I think there's a real possibility. Or if she is going to go the avenue of, I think I have a good appeal, I am not going to ask for forgiveness, I'm going to maintain my innocence, then it's probably best to say nothing. You can't go full Sarah Boone at sentencing. That was a unwise choice. She probably thought it was great, but that is an unwise choice. Lolly 67 in the chat said, wouldn't they just offer her a plea? I imagine they are going to wait until the sentencing in this case is done before they decide what they're going to do next. So they could plea the financial case, but I don't think that's even a reasonable conversation before sentencing in this case. And maybe it is, maybe that's going on, but I imagine the focus is on sentencing and appeal. So, Polly Sykes said, I didn't see the Sarah Boone sentencing. Perhaps I should check it out. Yes, you should. Yes, you should, especially if gaslighting at sentencing is interesting to you. There are some things that happen in the Boone sentencing that I have never seen before. And I spent a lot of time in court. I love that I still get surprised, but wow, it was a choice. That was a choice. That was a choice. I would watch the sentencing. and I would watch the next coverage after the sentencing. A little bit of spoilers because Sarah Boone was a while ago. A little bit of spoilers. At the sentencing, Sarah Boone's attorney tried to mitigate the damage that she was going to do to herself and tried to take things out of what she wanted to say to the court and kind of rein it in a little bit. And then after the sentencing went down, she went, fuck it, send it, and sent the letter to the court, the unredacted letter to the court, and was like, this is what I really wanted to say. And my attorney told me to rein it in, but I'm not reining it in now, and just sent it. Oh boy. It was a choice. It was frustrating to watch. It was frustrating to watch. I think early on in the sentencing, the victim's family walked out of the court, and I'm glad that they did. Sparkling Rutabaga said, I missed all the Sarah Boone stuff. We have a supercut of that video. So if you want to just watch one video with the entire trial, we have a supercut of the video. I think it's like 50 hours long. But we have a supercut of just the trial. So you can go to just one video and watch the trial start to end. We cut out all the lunch breaks. We cut out all the breaks in the day or Zoom. And we sound balanced it. So if you happen to fall asleep during that video, the sound is all balanced. But there's a 50-hour video there. Also, if you lose your place in, my necklaces are getting twisted. If you lose your place in the playlist, you don't have to worry about it in that video. We're working on doing supercuts of some of our other trials. It just takes some time. I don't know if we'll be able to get all of the trials we've done into one video. It might be a part 1, part 2, because over about 50 hours, it gets a little tough to upload. We had to get special permission to get that one uploaded. We needed actual help to be like, so hey, can you help us get this video uploaded? We needed the powers that be to actually allow it to be uploaded because it's so long. So we might have to do them in like a part 1, part 2 for some of the other trials that are going to be longer than 50 hours. But yeah, we are working on doing some supercuts. So that is in our docket. All right. So with that, let's see. Go watch the Sarah Boone sentencing. Not right now. But if you did not catch the Sarah Boone case, it was a much more interesting trial than I thought it was going to be. There were parts of it that were way, way more intense than I thought they were going to be when they got into the rebuttal case. It is the Sarah Boone case is a fantastic example of a lot of things. One, Florida does not fuck around at all. Florida's like, no, sir. So Sarah Boone got life without parole on a 2nd-degree murder. 2, the attorney was doing the best they could with what they had, and you can really see it. The client you have can make a difference. And when your client wants to go forward with a particular defense that opens the door for a robust rebuttal case, this is one of the trials where I have seen the most robust rebuttal case. So the Sarah Boone trial, which is a 2nd-degree murder, she had zipped her boyfriend into a suitcase and not let him out. The videos are really sad. But her defense opened the door to a ton of stuff in rebuttal, and it was one of the strongest rebuttal cases of a case that we've watched together. And so if you are interested in what, we've opened the door to a crazy prosecutor rebuttal, the Sarah Boone case is a really good example of what that looks like, of things that didn't come in the case in chief, and then they opened the door right up, and it was like, whoa, wow. If you knew that was behind door number 2, why are we opening it? And then sentencing. It was a lot. But also just keep in mind that Sarah Boone thinks she is smarter than all of you. So we just don't understand. We're going to have to check back in with her appeal in a little bit, because she has had a hard time keeping attorneys on appeal. So one of the attorneys completely switched jobs, went from being a defense attorney to being an attorney general. I was like, you've completely switched sides. I don't think that was done to avoid Sarah Boone, but it's funnier to think that it might be. That's the funnier outcome. I don't think it's the actual outcome. All right. Are we ready to go to Massachusetts? I feel like we're wrapped in Utah. Utah, give me 2. Kouri Richins is probably going to get a new sentencing date. The defense has valid reasons for asking for it. I think a full day of sentencing is reasonable. It's probably going to move the sentencing date off the victim's birthday. Is that a bonus to them? Maybe. But are there also reasons here that are valid to ask for that sentencing date to be moved for Kouri Richins? There are. There are valid reasons to ask. And I guess we'll have to wait and see what her attorneys put on as defense and how they decide to do that. So we'll see. It's good. That's where we're at. Are we ready to go to Massachusetts? I think we're ready to go to Massachusetts. Cheers, law nerds. What are we doing in Massachusetts today? Well, the rest of stream. Let's do a quick overview of what we're doing in Massachusetts before we fly to Massachusetts. Well, first, another one bites the dust, and we're going to talk about that. Second, we've got more Proctor problems. We got phone problems. We got memory problems. We got discovery problems. And we're going to do a little bit of an overview of the federal case. We have not looked at the federal case in a minute. So we are going to look at the federal case together with an overview. And then we will go beyond that, probably tomorrow, back to the wrongful death case. Remember, no, I'll save that for the road so far. I'll save it for the road so far. Also, the last time we actually played snippets of Queens, another one bites the dust, everything got cranky with us. So just dun, 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 another one bites. There we go. Because we're going to have to talk about yet another officer who has rehomed themselves right out of state troopers. So just roll it in your mind. But before we do that, and because Emily likes to make sometimes the funnier decision and maybe not always the better decision, we do rely on our sponsors. And today we have a stream sponsor that has allowed me to not only share with you that Incogni is how we keep all of our data off the internet as best we can, but also they let me share with you updated information. I feel like we have like an Incogni segment once a month, updated information about security breaches that I find interesting / horrifying / look, everybody, duck and cover. Because now that especially we have, AI scanning our emails, even if we don't want it to, you never know what information can end up on the web. So if you've thought, nobody's looking for my information, that's not really how I see it, because a lot of this is not like looking for your information to come and knock on your door. A lot of it is looking for information to call you and pretend to be someone in your family that needs you to like wire them $500 because they've been in a car accident or something. It's those types of scams that are becoming more and more of a problem. But you are going to, I don't know, let me know in the chat if you have heard about this breach, because the fact that this has not gotten more coverage frustrates me quite a bit. And guess who it has to deal with? The FBI! So a huge thank you to today's sponsor, Incogni. Leonard, a huge thank you to today's stream sponsor, Incogni. Not only is Incogni who I trust with my personal data and my family's, but also the more I keep an eye on what's going on with data breaches, the more I am confident coming here telling you it's not a matter of if, it is simply a matter of when. Did you see this latest FBI breach? Yeah, you heard me correctly. The FBI! Look, if the FBI cannot keep their data locked down, what hope is there for the rest of us? Well, that's why I have Incogni. Incogni goes out to all those data brokers and gets your information taken down. But it's not just that Incogni does this once. You sign up once, and then their system is fully automated, and it keeps scouring more data brokers. And Incogni is one of the only places that I've seen offer a custom removal feature where you can work directly with Incogni privacy experts to handle specific and customized takedowns of information online. And Incogni helps you protect your privacy in just 3 easy steps. You just create your account, you put in the information that's needed, you authorize Incogni to remove it, and then they go and remove it from the web, and they keep removing it from the web. And Incogni is the first and only personal data removal service to be independently verified by Deloitte. And Incogni knows you're going to love it And just in case you don't, they offer a 30-day money-back guarantee, so you can cancel anytime. Leonard, I know you're ready to check out Incogni for yourself, and now is a great time. Use code EmilyDBaker at incogni.com/EmilyDBaker to get an exclusive 60% off an annual Incogni plan. That's 60% off an annual Incogni plan when you use code EmilyDBaker at incogni.com/EmilyDBaker. Or check out the link below and in the chat. And of course, thanks again, Incogni, for sponsoring this stream. Let's get back into it. All right, law nerds. Yes, the FBI did in fact have a massive data breach into their wiretapping system. I have not seen that breach reported almost anywhere. It's wild to me that, foreign actors were able to get into the FBI's wiretap and find out who was being wiretapped. And well, we'll see how much they accessed, because it is absolutely wild to me. But that was one of the latest breaches. I know we talked about PetSmart last time, but I've hardly seen that breach covered. It's wild to me. So with all of that, thank you again to our sponsor, Incogni. It has been a product that I've used since before Incogni was sponsoring, though I have been sponsored by Nord since almost the beginning of my YouTube channel. They were one of the first sponsors that reached out and were like, hey, we like what we're doing. We like what you're doing. We would like to share that with the folks, and has been a sponsor on this channel since, and I appreciate it. So yes, PetSmart was one of the breaches that we talked about, I think, last month. So who knows what we'll talk about next month. But today it is time for us to get back to Massachusetts, because it's been a minute. I know it's been a minute. A lot went on while we were in Utah. We were in Utah a bit longer than I thought we were going to be in Utah for. And we were in Utah for Kouri Richins, and then things were popping off with Taylor Frankie Paul and Dakota. And then there's divorce stuff going on, and all of the like Secret Lives of Mormon Wives stuff blew up. And then it was like, okay, well, we're going to cover some of that. And we don't do a lot of civil restraining order hearings. So we did that. And then people were like, I absolutely hate it here. Restraining order hearings are tough. And we're going to watch the rest of it. It's going to be tough. It's a lot of this. So we were in Utah a little longer than I thought, and things have been speeding along in the multitude of Karen Read cases. So what we're going to do today is we're going to fly to Massachusetts. Then I think we look at the Proctor phone discovery first, because that is taking place like a case within a case within the pending criminal cases of Miles King and like 5 other defendants. So I think we take care of the Proctor phone stuff first, which gives us a little bit of background before we jump into recent filings as recent as yesterday in the Karen Read federal civil case. But it also gives us a heads up where the Karen Read team is looking at going. And then it sets the stage, I think, for what we're going to be talking about tomorrow, which are more discovery issues in the civil wrongful death case. Emily, that's a lot of cases. Yes. So discovery issues are playing out in the criminal cases of non-related criminal defendants because they have to do with Proctor's personal phone. Then Karen Read was sued by the O'Keeffes in civil court in the state of Massachusetts and wanted to bring in all the cross defendants. Like Karen Read sues them all, wanted to bring the cross defendants into the wrongful death case. And the court was like, I don't know if we're going to do all that. And then it got removed to federal court. So then the Karen Read sues everybody is in federal court. The wrongful death case where the O'Keeffes are suing Karen Read is in state court. And the Proctor phone fight, OPP? Other Proctor phone fight? I mean, if we get creative with the spelling of fight, the Proctor phone fight is in the other criminal cases, also in Massachusetts, which also gives us a heads up about another case that it looks like Karen Read is thinking about bringing. That was as best of as an overview, and I think we'll road so far each case as we get to it. Does that make sense? Let's fly to Massachusetts. Buckle up, everybody. It's going to be busy. So with the Proctor phone fight or other Proctor's phones, as some of you have suggested in the chats, Proctor's other, well, either way, we will remember that we saw the Proctor texts in the Karen Reed criminal trial. And it seemed that Proctor was not worried at all about all the shit that he was texting to his supervisors and whatever. There was an entire like half day of testimony of Buchanan being like, no, I thumbs up it on my Apple Watch. I didn't really read it. I gave it a thumbs up on my watch. It was on my watch that I thumbs right of all of the texts. We're not going to forget the texts. That is a moment where I was pretty glad that we went into that trial as a juror, because I was like, no way. It was one of my favorite Judge Cannoni moments when Trooper Proctor was trying not to see you next Tuesday. And she's like, are they your words? Then say them. I was like, damn. Also correct. Make him say that shit to the jury. Make him say that shit to the jury. Make him say it. So after that, in the ongoing criminal cases that Proctor was continuing to deal with, other defense attorneys, because of course they did, were like, yo, what else is on Proctor's phone? And whatever triggered them getting into Proctor's personal phone, right, OPP? When they got into Proctor's personal phone, the discussion around the personal phone from Proctor's attorney before Proctor withdrew from the civil service hearings. So this was all ramping up to Proctor fighting his termination. And in fighting his termination, he was like, you know, other people don't get fired for this. And I mean, maybe that's part of the problem, but other people don't get fired for this. And I'm being targeted, persecuted, if you will. Surprised Proctor didn't bring up the Salem witch trials like the TikTok psychic did. You know, other people's persecution. But he's like, I was being persecuted, if you will, politically for, you know, unequal treatment. Other officers were not fired for this. No one gets terminated for this. And this was, I was being treated in a discriminatory fashion in being terminated in this way. And then they had done a phone dump of Proctor's personal phone. Remember, Proctor's attorneys said, and we saw this in court filings, Proctor's attorney said, don't worry, there's probably not much there, because he had gotten a new phone, rehomed a phone again. He was just like, I don't like the color of this one. I'm going to get a new one. I'm sure it had nothing to do with the color of the phone, but Proctor's new phone. And his lawyer was just like, there's not going to be much there. And then apparently Proctor's iCloud was connected to the phone, and they got a phone dump of 13 years plus of information from Proctor's iCloud. Thousands and thousands of texts and photos and videos and emails and pictures and all of the things. And the Commonwealth says, oh, hey, Jan, I know you said there probably wasn't anything there. Wrong. She's telling them everything. So here's everything that we found. And the very next day, Proctor withdrew his appeal at civil service and was like, fine, I'm fired. And then his attorney was like, and we're out. We were the civil service attorneys. We represented him in civil service. He's out of civil service. We're out. All happened like the next day. And then the fight began in court over what was going to get turned over to the defense attorneys in the 5 ongoing criminal cases where Proctor was like the lead investigator, not the lead investigator, case agent, whatever, because they can go to bias. If he's talking about Karen Reed the way he's talking about Karen Reed, do you think he's not talking about other defendants similarly? I don't. I think that's how he's talking about everybody, because he, well, seemed awfully comfortable giving information about a case to his sister, talking about a victim before a victim had even been identified in the case, talking about the outcome in the case before a victim had even been publicly identified, and the rest of it. The man was awfully comfortable. So no, do I think that was new behavior? I don't think that was new behavior. That's my opinion. So then the fight began over what information from the personal phone gets turned over to the defendants in the Miles King et al. Cases. That's the case we watched the hearing on where Lally was testifying on the stand. And I was like, what the fuck's with prosecutors getting on the stand? And then they're like, okay, so when you don't get this, what do you do? And Lally's like, I ask for it again. What is your discovery process? I ask for it. It's an ongoing obligation. That hearing. When I lost my mind that it's been like 5 years into a murder prosecution and the defense still doesn't have like the search warrant. Yeah, wild stuff. And I was like, how is the defense bar in Massachusetts still like going to court every day and not just literally walking into court screaming and walking out? Because I don't know if I could deal with the level of frustration that we're watching play out. Just case after case after case of like the most basic aspects of discovery being a fight. What are we doing? So it seems, and we will talk about other cases in Massachusetts shortly, not today, but it seems that this is maybe not unique to just this case, which also shocking, just shocking, but also, the defense bar in Massachusetts, it's like, yeah, surprise. At least y'all get to see what we're dealing with. Woohoo. It's wild. So in the Miles King and other cases, the fight over Proctor's phone was allowing information to be turned over to the defense attorneys in those 5 criminal cases. And then Karen Reed's attorneys were like, hey, can I get that discovery? See, we've got this other case in the wrongful death case. And part of Karen Reed's defense in the wrongful death case is a conspiracy, a failure to investigate, a cover-up, and a setup. So the shit on Proctor's phone, you can see how it would be relevant to her defense in the civil case. It is incredibly unusual that the civil case would be asking for discovery in a criminal case that is not related to the civil case. Karen Reed's not a party in any of those cases, but it's discovery about a witness from their civil case, and it is related to their job as law enforcement because it's a wrongful death case, and part of the defense is but law enforcement. So then they were going through hearings where the Commonwealth was responding, Proctor was responding, and Karen Reed was responding, and the criminal defendants were like, it wasn't me. Like, this is not my, I have nothing to do with this. It wasn't me. So as they went through those arguments, and we covered a lot of those filings, but as they went through those arguments, it was agreed by the court. And remember, they were fighting. This is when they were fighting over what evidence would be destroyed by the feds and what wouldn't be and what more there was. And could the Reed attorneys get it? And then could they use it? And what kind of protective order would there be? And then when they were talking about the protective orders, it was like, well, there's some stuff that's really sensitive on his phone that we need a protective order for because there's sensitive shit on his phone and we can't just have that everywhere. And they came to an agreement, and the parties in the wrongful death case were given a part of the discovery from Proctor's phone. They did not get like the entire phone dump from Proctor's phone, but they got part of the discovery under a protective order. The protective order really clearly defined what they could use it for, what they couldn't use it for in the civil wrongful death case. But then, Karen Reed's attorneys went back into court and were like, hey, so about that, you've allowed us to use Proctor's phone in the wrongful death case. But we also have this other civil case where we're suing Proctor and like everybody else. So what we need is to be able to use what you've given us in the wrongful death case. We need to be able to use that in the federal Karen Reed sues everybody case. So could we modify the protective order to allow it to be used in the state case and in the federal case. Okay, thanks. And that's where we're picking up in the middle of phone fight part 2 over Proctor's phone. Because now Karen Reed and her attorneys are asking the court to expand the protective order to cover use in another case, which doesn't seem like a wild request to me. It's not, there are times when attorneys do shit and I'm like, what the fuck are you doing? This is not one of those times. It doesn't seem to me that this is an unreasonable ask. You gave us this discovery. We were allowed to use it in the wrongful death case. The wrongful death case is very closely connected to Karen Reed sues everybody. So can we just use it there? And, well, the Commonwealth has objected. Proctor has objected. Karen Reed has responded. From what I can see on the docket, the court has not ruled on this yet. It seems to me to be a reasonable request. I imagine, since the court has already granted it in the wrongful death case, the court will expand the protective order to also include the civil case where Proctor is getting sued. I think that's fine. And as Music to My Soul said in the chat, they're trying to embiggen the protective order. Yes, they are trying to embiggen the protective order. And that is where we're turning first. So the first case we are looking at, you will see that the headings are not one of the cases that we are covering per se. It is this discovery fight taking place under the umbrella of these other criminal cases where Proctor was the lead investigator, which when those go to trial are going to just be difficult because of the proctoriness of it all. I don't know how that's going to go for everyone. And some of these cases, it looks like most of these cases, based on what I saw on the docket yesterday, most of these cases have not gone to trial just yet. So let's look at some of the discovery fight happening in the Miles King case. Let me pull up the response. We are not looking at Karen Reed's request. I summarized. We are going to look at the Commonwealth's objection because I'm real curious about that. And we had already covered Karen Reed's request for the phone documents in the wrongful death case, and this is analogous. So let's take a look at that objection from the Commonwealth, because of course the Commonwealth has something to say. Commonwealth's response to third-party motion for permission to use materials recovered from former State Trooper Michael Proctor's phone. Well, at least it's titled well. This is stamped March 27th. So this is the recent fight. And for everybody coming in saying, where are we at? Yes, this was granted for the other case. This was granted for a different case. So it's not granted for this case yet. The Commonwealth responds to Karen Reed's motion for permission to use materials that this court has limited dissemination of in litigation not before this court. I'm going to bring my desk down a little bit. We're going to Emily, are we just getting cozy? Yeah, we're just getting cozy. We're just getting cozy because we have so much to do today. Karen Reed is not a party to these pending criminal cases, nor has she moved to intervene. But they've already granted it. They've already granted it. What are we? The court already allowed Reed the right to intervene by granting the last request. Rather, they say, Miss Reed, in a highly unusual set of procedural circumstances, seeks this honorable court to act as the gatekeeper for discovery in unrelated and anticipatory civil litigation. Well, the federal case isn't anticipatory. They're suing Proctor. On January 23rd, 2026, the Commonwealth moved to provide, pursuant to a civil subpoena, information derived from former Trooper Proctor's phone. The Commonwealth's motion was a good faith attempt to resolve a subpoena and pending motion to compel in the civil matter. And that's the O'Keefe versus Karen Reed and the Bars civil matter. And they go on to say that that's a wrongful death action against Karen Reed pending in Plymouth Superior Court. Prior to filing, the Commonwealth engaged in extensive discussions with Miss Reed's counsel, and the proposed order incorporated those discussions. Agreed to at the time was that the use of the material would be limited to the O'Keefe litigation. Whereas a confidentiality agreement signed by all parties and endorsed by the Plymouth Superior Court restricted discovery in a manner substantially equivalent to the defendants in the above caption and other unrelated criminal cases who similarly received the material through that court order. Right, because they had to give it to everybody. And they go on and list the other criminal cases. Following a hearing on February 26, 2026, and over the objection of Michael Proctor, this court permitted the Commonwealth to produce to counsel for all parties in the O'Keefe litigation portion of Michael Proctor's cell phone extraction related to bias and to search for any material related to the death of John O'Keefe, Exhibit A. Footnote 2, which is the order. The order limited the material to the O'Keefe litigation and incorporated the Plymouth Superior Court's confidentiality agreement. The cell phone extraction related to bias was produced to the parties on March 9th, 2026. Miss Reed now unilaterally moves to amend the court's order to go outside of the protective order for discovery purposes and to permit the use of the material for new claims against Massachusetts State Police and the town of Canton. So there is a third lawsuit brewing, and a lot of you have asked about, is Karen going to sue the government entities? Yes, and separately from the other cases. Like, this is the song that never ends. It goes on. Yes. Yes, because not done. Let's look up footnote 3 real quick. On December 10th, 2025, this court allowed the Commonwealth's motion to provide biased material from Proctor's cell phone to counsel for the town of Canton and the Peace Officers Standards and Training Commission post. However, the use and dissemination of the material to those parties is equally restricted. The Massachusetts State Police currently have no access to this material without further amendment of this court's order. Oh, so MSP has it. And Post has it. But here's the pickle. If Karen Reed tried to subpoena it from MSP, what would MSP say? Oh, well, we're under a court order. We can't give it to you. You have to go ask the court. Okay. And then we'd end up right back here because the police would say, we can't give it to you. It's under court order. Emily, you're telling me, yes, that they are fighting over material that she already has. Yes. That her attorneys have already had their eyeballs on. Yes. That they have in their possession. Yes. And they are arguing in court that she can't use that material to sue the agency that employed the person who was a part of all of this. Yes. But they have it. Yes. But they've seen it. Also, yes. Yes. You are correct. Yes. But so why can't they just use it? Because there is a protective order over it. And so this is a ask permission, not forgiveness situation. Because if you try to ask forgiveness, this situation, you don't get to use it at trial. You don't get to use it at discovery, and you can get sanctioned. So this is an ask permission. But because everything in this case is so unusual, we have ended up in an area where if Karen Reed, let's run through scenarios. So in the federal case, Karen Reed's suing Trooper Proctor. So Karen Reed can ask Trooper Proctor for his phone. She can try to subpoena Trooper Proctor's phone. He's an opposing party. Guess what? They tried to do that. Guess what? Phone was gone. Whoops-a-doodle. Didn't have the phone. Phone was gone. Well, okay. So his employer has MSP has a download of the phone. Great. Hey, MSP, can we have a download of the phone? Oh, no. Sorry, that's under court order. We can't just give that to you. Okay, so who else do you ask for it? The court, which is what they're doing. But they are saying that this is related solely to the anticipatory suit against MSP and Canton. That's why they're calling it anticipatory litigation, because that has not been filed yet. There are steps you have to go through to sue government entities. There are hoops that you must jump through. This is not one of the anticipated hoops. This is a side quest hoop. This is you fell into a bonus realm hoop. This is a bonus realm of discovery. Not everybody knows it's there. So there isn't really a procedure to get discovery directly from Proctor if he's oops, it's gone. And to get it from MSP if they're whoops, it's under a court order. So you just have to go to the court. So we're in court and the Commonwealth is yeah, but no, there's nothing we can really do about it. And the Commonwealth is saying there is no pending civil litigation, no subpoena issued, no court governing discovery, including no confidentiality agreement among the parties. They just want to expand the confidentiality agreement that exists, though. They want to expand the confidentiality agreement that exists. They're not asking to just let it go. They're just asking to expand the confidentiality agreement that already exists. It's kind of disingenuous to me to be there's no confidentiality agreement, but there is. You just need, as to the read parties, they may use it thusly. That's all. But no. The Commonwealth says there's no pending civil action, no subpoena issued, no court governing discovery, including no confidentiality agreement, no legal basis or jurisdiction for the request. As was previously done, the Commonwealth is amenable to discussions as a third-party record holder if and when a subpoena is issued in a further civil action, such that discovery can be similarly governed. Moreover, when the Commonwealth moved to produce the material, it was done in response to subpoenas, but also in fundamental fairness to all parties in the civil action, as all were signatories on the confidentiality agreement. Ms. Reed's request would place parties in the current unfiled action at a disadvantage as they lack access. Oh no, MSP doesn't have access to Trooper Proctor. MSP had access to Trooper Proctor. MSP knows more about Trooper Proctor than Karen Reed does. Oh no, MSP doesn't have access. They also have the discovery. They can also get a court order. I'm not going to have enough coffee to get through this today without crashing out. Okay, it goes on to say Ms. Reed's request would place the parties in the currently unfiled action at a disadvantage as they lack access or means to use the material in a similar fashion, notably resulting in an onerous and unduly burdensome task for this court to continuously schedule hearings, amend its orders, and serve as the gatekeeper for anticipatory and unrelated civil discovery disputes. Therefore, the court should deny Reed's request or take no action and reserve for a time when there is appropriate legal process. Okay. I think they think this is appropriate legal process. But okay. That's what the Commonwealth had to say from attorney Laura McLaughlin. You saw attorney Laura McLaughlin in the Karen Reed prosecutions. Laura McLaughlin's not the only one who has something to say here. Trooper Proctor also has something to say. So we're going to take a look at Trooper Proctor's opposition to the Reed party's motion for the embiggening of the protective order so they can use it against. And I mean, I guess maybe what everyone wants them to do is just keep subpoenaing it subpoena it in the federal case, and then subpoena it again when you've sued. Proctor has thoughts, or at least some of them. Not when texting, but otherwise. Commonwealth of Massachusetts versus Miles King at all the other defendants as well. Third party Michael Proctor's opposition to Karen Reed's motion for permission to use materials recovered from, they don't say former trooper in this one. The headings are different. Can we keep the headings the same? The Commonwealth's heading is Commonwealth's response to third party motion for permission to use materials recovered from former state trooper Michael Proctor's phone. Proctor doesn't say it that way. Proctor changed the heading. Third party Michael Proctor's opposition to Karen Reed's motion for permission to use materials recovered from Michael Proctor's phone in related Superior Court proceedings. Notice the change? That wasn't by accident. I noticed the change. I clocked it. That wasn't by accident. But also, come on. This was also filed March 27th, 2026. Now comes interested third party, former trooper, Michael Proctor, and hereby request that the court deny Karen Reed's motion for permission to use materials recovered from Proctor's personal cell phone and related Superior Court proceedings. They even quoted it. Okay. It goes on to say, as grounds, therefore, Proctor states Ms. Reed has not met her burden to establish that the data from Proctor's personal cell phone is relevant or material to any claim she may have against his former employer or the Canton Police Department, or any negligent hiring, training, or retention claims under MGL 258, the Massachusetts Torts Claim Act. But numerous supervisors were disciplined for failure to supervise. We're going to talk about that next. But numerous supervisors were disciplined for failure to supervise. It goes on to say, furthermore, upon information and belief, there are no protective orders in place in any of the, quote, other Superior Court cases referenced by Ms. Reed so as to prevent further dissemination of the February 26, 2026 production. Moreover, the release of said data would certainly compromise Proctor's privacy interests. Oh, we're now at other people's privacy. And possibly those of other individuals referenced in the data. Should the court allow Ms. Reed's motion, Proctor respectfully requests that the court also issue an order to the Norfolk District Attorney's Office mandating that it turned over to Proctor's counsel copies of the documents that it produced to Ms. Reed's counsel following its February 26, 2026 order of protection. I really wish they had the sophistication to just watermark all of this shit. Can you just figure out who did Taylor Swift's wedding invitations or whatever to watermark it so if anything gets leaked, you can just track back to whose copy it is? I imagine this is possible. Doesn't Hollywood do this with scripts all the time? And then they give different versions of the script and then it's all embedded with information so that if anything does get leaked, you can trace it back to who leaked it. Is this not possible? Maybe it's not possible in Norfolk, but it seems that there are other options here. It goes on to say that and this is why I wanted to cover this. The February 26 production was extracted from Proctor's personal cell phone in or about September 2025. Upon information and belief, it contains millions and millions of pieces of data, allegedly going back almost 13 years. I love that. I love that. I love that for you all. I love this for you. I'm not sorry about being petty in this one. No, I love that for you. I feel bad for the individuals that are in Proctor's phone. The other defendants that are talked about, the individuals who don't even know they're talked about. I genuinely am concerned for the other individuals in Proctor's phone having their information on the internet. That concerns me deeply. And I think that is a valid and real concern. I have no concern about protecting him from being embarrassed. I have concern for others discussed in the phone. But Proctor whoopsie-doodled lost the phone. This all came to light when they were asking to get Proctor's phone, and it was like, oh no, he got a new phone. And then they found 13 years of information. I don't think he just lost a phone. I find the coincidence to strain credulity for me that he just lost a phone. I mean, did he lose it into cement at the bottom of the bay? Where's the phone? I think it's interesting that they were unable to recover anything from Kouri Richins' iCloud, but yet they have 13 years of Proctor's. Isn't that funny? Either way, love that for him, because I do think the fuckery should come to light. I think it should. Absolutely should. According to the district attorney's office, the data contains highly sensitive information, including images of intimate body parts of people. I'm glad that they specified, I guess. Screenshots of Facebook posts by non-participants. Oh, I bet it does. Full phone numbers and personal email addresses of others, and the name of sexual assault victim. It says victim. I don't know if that's singular. Also, this is your personal phone. Why are we doing work things on the personal phone? That's how they got to the personal phone in the first place. Don't do work things on the personal phone. It goes on to say that upon information and belief, the February 26, 2026 production contains some of this highly sensitive information. Miss Reed acknowledges the same in footnote 2, page 2 of her motion. And then they're saying what Reed put in her motion. The data references information relating to sexual assault or harassment victims or individuals whose images were shared without their knowledge. However, Miss Reed's motion fails to explain how any of this personal information would be relevant to a negligent hiring, training, and supervision claim against MSP. Well, I can see how it's relevant if you are discussing this with other members of MSP on your personal phone that might be your supervisor and they don't have any problem with it. I mean, that you're in conversations on this phone with your supervisors. We heard about that in the other motions. So that's how it's relevant. However, they say Reed's motion fails to explain how any of this personal information would be relevant. There is no allegation anywhere in her motion that Mass State Police knew or should have known about this information on Proctor's cell, nor does it allege that such information might have been discovered during a background check of Mr. Proctor prior to hiring him. No, I don't think that's the issue. I don't think this is a background check issue. I think this is you're in conversation with your supervisors on the personal phone and everybody thinks it's fine. That's what I think the issue is, but that's me speculating. It goes on to say Reed's motion fails to explain how the data might be relevant to a claim against Canton Police Department. Well, it might not be relevant against Canton, but if you're suing Canton and MSP, it might be relevant against MSP. Unless you're also talking to Canton cops on the phone, and then it is relevant to Canton, isn't it? Additionally, it goes on to say the use of this data in certain Superior Court proceedings is almost certain to be leaked publicly and is likely to be used in public hearings or trials. But then it's governed by process. It's governed by due process if it's happening in public court proceedings. It goes on to say, upon information and belief, there are no protective/confidentiality orders in place in these civil superior court matters. Well, there is in the wrongful death case. Furthermore, the internet is already rife with information. The sentence made me buffer, I'm sorry. Furthermore, the internet is already rife with information data concerning Miss Reed's trials. Huh? Can y'all just... What? What does it have to do with it? Like, what does the internet have to do with it? Like, go get it from Reddit? What is... I'm not suggesting that it's there. I don't think it should be. And I don't think that it is. But what is the suggestion here? That the internet has Trooper Proctor's phone, and so therefore Karen Reed doesn't need it to bring into court? I don't even know what this point is getting to. It seems like an odd sidestep. Like, I don't understand how in just the writing construct of this, we get to there's no protective orders. There should be protective orders. Fine. But how do we jump to the internet is already rife with information data concerning Miss Reed's trials, her conviction for operating under the influence, and other information regarding Proctor, the witnesses in the case, not this case, but Reed case, the decedent John O'Keefe, non-parties and non-witnesses of the case, and the matter generally. So? Oh, keep reading. In short, the use of this information will likely add fuel to the fire. See Commonwealth versus Aidan Carney, Memorandum and Order on Defendant's Bail Petitions, attached as Exhibit 1. No, we're not going through them. They put in paren, remember, this is a filing from Trooper Proctor, noting Mr. Carney's harassing conduct of Proctor's wife, a non-party to Miss Reed's trials, and others. See also, and then they link his Twitter handle. Okay. So, okay. So the argument is that the internet was mean to Proctor and his wife. Therefore, Karen Reed shouldn't get the discovery relating to an individual not Karen Reed, and we're just throwing shit in to complain about it. Like, why are we stepping on a hornet's nest in our own motion? What are we doing? Okay. This is a choice. This is a choice. This is a choice. I mean, I don't think this is related to their motion. Clearly, my opinion. But Your Honor, the internet will have more fuel to the fire. Okay. Maybe these attorneys think that this argument will persuade this judge. Maybe that's where their head's at. But Your Honor, the internet gestures vaguely at all of it, not at the Lawnards, because they would never. The Lawnards sit back here and are like, no, we're not adding fuel to the fire. We're extinguishing your flame. And then we will never speak of your name again, so that you will just fade away into obscurity. We're more of a smother type of situation. We're just going to fade away. Maybe nobody brought Proctor cookies on his birthday, and that's why he's so mad. This motion goes on to say, it is well known that Proctor, his family, as well as independent witnesses in the underlying criminal trial have been followed, tailed. How are those things different? Please, somebody tell me that it's different. How? They have been followed, tailed, photographed, and had their personal privacy interests interfered with by Miss Reed's followers. I don't know that that necessarily follows that they were Reed's followers. I don't know that that necessarily follows. I think people following the case is separate and apart. But I'm also very much a don't go real world. However, you cannot stop people from having negative opinions, especially when they're well-founded. Don't go real world, but also, what are you talking about being photographed? Are you talking about walking into the courthouse during trial or what? Like, I'm not surprised that the community is outraged. It is, in fact, outrageous behavior. So, yeah, the community is outraged. I mean, y'all went and arrested her twice. So, there's that. It goes on to say that to allow this information to be used in other superior court cases would prejudice Proctor, witnesses in underlying, would prejudice Proctor, what, and witnesses in the underlying criminal matter? Is that a period? Or is that, no? And possibly other unnamed individuals, and cause further embarrassment and harm to their reputations. I should have just kept reading. They've gutted this entire unit. They're under investigation. Let us not even get into the Birchmore case today. Y'all embarrassed yourselves. This has nothing to... Y'all embarrassed yourselves. This is not unjustified criticism of how y'all did your jobs, because it's appalling behavior. It is unprofessional. It is not in integrity. And the entire unit has been gutted. People have been fired. People are under investigation. People, oh no, lost vacation days. People have been found to fail to supervise. This is a massive problem. The reputational harm is done. And a lot of that, at least for me, because I watched the trial and I've covered the filings, I don't delve into the internet fuckery. And honestly, even when you guys send it to me to be like, hey, just a heads up, this is going on, I'm like, I can't, there's too much fuckery. I cannot fuckery afoot. I just want to focus on what's going on in court. So my view of this case is informed by what I watched in trial, what I've watched in court hearings, and what I've watched in dockets. I've not covered the Turtle Boy case. I've not followed the Turtle Boy case. I've not followed them running down the rabbit hole to go after Karen Reed for witness intimidation. I haven't followed those things. I followed what happened in court. And what happened in court was reputationally damaging because it was bad. So that was y'all's testimony in trial. We just watched it. We watched the testimony in trial. None of the other stuff. That's what I am relying on. They think it's deeper than that. It's not deeper than that. Trial did not go well. Goldie, it's totally fine. Goldie said, I like all the fuckery. I'm not above it. I'm not telling you you have to be. I am not telling you you have to be. My firmest suggestion is don't go real world with people. But if you want to sit back and watch the shit show, go right ahead. I just say don't touch the poop. Go ahead and watch the shit show all you want. No touchy. That's where I'm at. The other part of it is I appreciate the awareness that's like, I know it's a shit show and I'm choosing to watch. Make that choice. Make that choice. Be like, holy shit, this is unraveling faster than Scandival or Summer House. Fair enough. Totally fair. Because y'all acknowledge that it's a shit show. And you're like, we know that it's fuckery. We want to watch the fuckery. We see that it's fuckery. And some of you opt out. You're like, nope, I just want to know what's happening in court. The fuckery stresses me out. It's like listening to my kid come home and talk about a whole bunch of people who I don't know. And I'm like, who did what to who? What? They got in a fight in the hallway because he's cheating on her. How? Did his mom drive him to meet up with another girl? Like, what's happening? Y'all are in junior high. She doesn't go to your school. Oh, that's part of the problem. Oh, well, I see. Does she live in the neighborhood? They like meet up on a bike ride? Like, what's happening? I don't know any of these people, Griffin. I need more details. Who's cheating on who? Oh, and then it blew up at science camp. Oh. Good thing they didn't go to the same science camp then, huh? But I don't know. But I want to know. Like, tell me the fuckery. Sure, tell me the fuckery. But also, like, I don't know. And sometimes if it just stresses you out, it's okay to be like, I'm opting out of the fuckery. It's way too much because it doesn't stop. I think here's where I'm at on the don't touch the poop. Don't touch the poop. Don't go real world with people. I have no problem. If y'all want to watch, watch. What I love about this community is that y'all also know that when I'm covering a case and I'm saying I'm just focused on what's going on in court, it's because I want to try to just see what's happening in court without being influenced by what's going on outside of court. And if I know things going on outside of court, I'll tell you. But there's also too much to keep in my brain sometimes. And so I'm just like, nope, we're just blinders on. We're just doing this because it's the easier way for me to cover the case. And what I love about this community is all of you get that. And you're like, no, I get where you're at. We're going to watch. I would never tell you not to. I also appreciate that you don't bring the spoilers in. It's so great. I love this community. Fuckery is a choice, for sure. I'm never going to tell you not to look at internet fuckery because there's some internet fuckery that's just like, what the hell? The first time, Emily, we've side quested. Yes. I don't TikTok, clearly. And I don't love an unlimited scroll. I also am starting to have a lot of just personal frustration with the algorithm being like, this is what you should see. And this is what you should not see. Like I have the algorithm's just like, let me curate what I think you like. And then you don't find anything new. Either way, TikTok's algorithm does that in a much wilder way than others, which is why people love it so much because they're like, no, it's like it's reading my mind. Right. But with TikTok, I don't like go down the rabbit holes of like niche drama in niche communities. But when the swinging scandal before Secret Lives of Mormon Wives broke containment, it ended up on my Instagram. Like that's how you know when something has gone beyond, like when it's jumped platforms and has landed in, like Mom Talk is not something I was engaging in at all. And it jumped containment and I was like, wait, what the fuck? Swinging scandal? Who are these people? Shit. They all kind of look the same. How do I know which one is which? What's happening? And then I was like, I need to know. I need to know what swinging scandal what is this? How did this end up? Shit. How did this end up on my Instagram? Who are these people? And what is going on? Who's getting divorced? Right. I was just pulled in. I'm like, damn it. Now I need to see. Now I need to know. I don't know any of these people. I don't care, but I'm so invested. So I understand. This one is a little bit harder for me because in the Mormon Lives, the Secret Wives, Mormon Lives, swinging scandal, it seemed that everyone had communications, but different expectations, and they all kind of chose where they were at, and then it all blew up on them. This is people in position of power wielding that power improperly will be generous here. And so this one's a little harder for me because it ruffles my feather in a very big way. And it is not, it frustrates me because it's like, I can see what's wrong and I can't do anything about it versus, oh shit, what'd y'all do? This one's a little different for me. Either way, that is my, you lost it for yourself, coach, is where we've gotten to with this, because trying to blame the internet for embarrassment and reputational harm is fucking wild to me. Like, what choice is that? It's the internet's fault. No. Y'all testified in trial. Proctor wants the court to deny the motion. Sure. Proctor wants the court to deny the motion. This is what's more likely to happen. Issue a protective order. Fine. Issue a protective order. Yep. Issue the protective order. Fair. Do that. Fine. I'm fine with that. Protective order makes sense not because of Proctor, because there are other people in Proctor's phone that should be protected. Agreed. How those people will get notified that they're in Proctor's phone is something I've got some questions about. I got some questions. But I think a protective order is appropriate. I do. Absolutely. Karen Reed responded on April 2nd. Well, Karen Reed's lawyers responded on April 2nd. So before we jump into the other Proctor problems, we're just going to round this out with Karen Reed's response. The court has not ruled on this yet. I am keeping an eye on it because I want to know what the court does. I'm real curious. So I want to know. All right. Karen Reed's response to Proctor being like, nah, they can't use it in other ways. Sure, Jan. My sure, Jan, was to Proctor, not to Reed's attorneys. Karen Reed's reply in support of motion for permission to use materials produced from former state trooper Michael Proctor's phone in separate related Superior Court proceedings subject to all other terms of the court's existing order and applicable confidentiality agreement. That is the entire title. That's the entire title. All of it. The Commonwealth and Michael Proctor collectively opposed Karen Reed's motion seeking permission to use documents subject to the court's February 27, 2026 order in two civil Superior Court proceedings rather than one. So they are not seeking this for the federal case. Okay. Fair enough. I think at the beginning I said they were seeking this for the federal case. They are seeking it for their presumptive case. Fair. I got it flip-flopped in my brain. Though I imagine when they try to subpoena it from Proctor and don't get it, they will come back and be like, we tried to get this from Proctor. He doesn't have it. So can y'all give it to us now? Imagine we'll be back there. So the Commonwealth and Proctor opposed Karen Reed's motion to use the documents in two Superior Court proceedings rather than one. Despite Reed's willingness to do so subject to the same exact restrictions that the court has already accepted and opposed. Did I read that sentence wrong? Is it just a very long sentence? The Commonwealth and Michael Proctor collectively opposed Karen Reed's motion seeking permission to use the documents subject to the court's February 27th, 2026 order in two civil Superior Court proceedings rather than one, despite Reed's willingness to do so subject to the exact same restrictions the court has already accepted and opposed. No, that's the sentence. That's not me. That, even though it's already been accepted, these parties oppose it. Why are they doing that? There we go. That's my summary. An awkward as fuck sentence. They do so on two main bases. Bases. They have 2 points. 1, Proctor's privacy. 2, the claim that this motion is premature. The court says neither, or the Karen Reed's team says neither warrants denial. First, The court has already reviewed the data recovered from Proctor's personal phone, OPPP, Proctor's personal phone, in compliance with the court's earlier orders and identified specific material that may be relevant to Proctor's bias. Proctor's counsel then had an opportunity to review the material the Commonwealth identified and remove anything privileged. Only the documents that remained were produced to read. These are statements to and from Proctor and his friends, including Canton Police Department Sergeant Sean Good. Whoop, there it is. Good, the one that's suspended, still suspended, right? Still suspended? Haven't come back around, still suspended, right? We think the suspension is based on all of this, but still suspended? I mean, there haven't been any hearings that we've heard about, but still suspended? Because of this? I mean, at least that's what I suppose, it was related to. It all happened right around the same time. I just Googled. It doesn't look like there's been much updates on what's going on with Sergeant Good. Maybe we need to take more of a looky-loo for tomorrow because we've talked about that. It's been a minute. We talked about that 5 months ago. Oh, we're definitely due for a check-in tomorrow. I'll look. Either way, was suspended, but the phone includes communications with Sergeant Good. The motion goes on to say they're not family communications, they're not private, they're not personal. They are, on the other hand, as Reed's team says, shockingly misogynistic, racist, and homophobic. I mean, I hate to say that. I don't hate to say it. It's just how I feel. I'm not shocked based on what we saw in trial. I'm sure the messages themselves are in fact shocking, but also it goes on to say that Proctor and the Commonwealth have no legal basis to continue to aggressively shield this non-privileged, non-confidential material in this manner. Despite this, Reed has agreed to comply with a series of strict restrictions contained in her confidentiality agreement. So that weird. Contained in her confidentiality agreement with the Commonwealth in order to facilitate production. They want to use this in court. They have a right to use this in court. And if those conversations are also with his supervisors, it does go to the potential civil lawsuit against MSP in Canton. It goes on to say that the agreement already protects any innocent third parties and prevents the use of any photographs of individuals that are unaware their images were being shared. Second, this motion is not premature. Reed is preparing her complaint against MSP and Canton. There is no legitimate justification for prohibiting her from using relevant statements and communications her counsel has or is aware of to ensure that the pleading she files is as comprehensive as possible and fully states her negligence claims right. Otherwise, you're going to end up with a motion to dismiss. You're going to get a motion to dismiss anyway. You might as well have the face of the pleadings be specific. It goes on to say that this is particularly true where Reed could already use those same communications in public filings in the existing civil case. The motion should be allowed. Your Honor, this is dumb. Your Honor, this is a dumb amount of red tape. Can we be so for real? Can we be so for real, Your Honor? We already have the information. That information also goes to our case against Canton and MSP. it would be dumbtastic to not allow us to use it in proper court proceedings, subject to the protective orders in place, so that we can explain what the fuck these dudes were doing. Thanks. Your Honor, please don't dumb at us. Please do not dumb at us. This would be a ridiculous result to be like, no, you can use it as part of your defense that the police department fucked up, but you can't use it to sue the police department for fucking up. Cheers. That would be the wildest result. Emily, put it in lawyer language. It would result in extreme judicial inefficiency and inequitable results in disparate cases based on some of the same allegations and parties, based on the information not being allowed to be used in multiple courts, which would be, as I said, both judicially ineffective and inequitable. So, can we just, they haven't ruled on this yet, but what Karen Reed is asking for is to be allowed to use the information that she already has in the wrongful death case as part of the basis of her lawsuit against MSP and Canton PD. And that information is from Trooper Michael Proctor's personal phone that's already been turned over by the court in the O'Keefe wrongful death suit, subject to protective order. And they have said that the protective order will be adhered to. But if, and this is an if, for example, hypothetical that is probably based in reality, but it is a hypothetical because I have not seen this discovery. If Proctor is texting with supervisors, things that would warrant discipline, questions, training, transfer of assignment, termination, whatever, and they're not doing it, it is a pretty strong basis of a failure to supervise claim. And numerous supervisors were disciplined for failure to supervise fucking Proctor. So if there's evidence in the phone, it should be allowed to be used. That's it. That's all. I agree. This doesn't seem like it should be hard. Proctor's like, but Your Honor, they already have it. But Your Honor, it could end up on the internet. They already have it. You're fighting over a protective order. I agree there should be a protective order. That's it. So, looking at Proctor's phone problems, will the discovery from Proctor's phone be allowed to be used by Karen Reed as part of her complaint when she sues Massachusetts State Police and Canton Police, which in these filings up until April 2nd, we see that they are contemplating doing? It seems to me that under the existing protective order, it should be allowed if it goes to failure to supervise and Proctor's bias. But speaking of failure to supervise, there is a supervisor of Proctor who has some interesting new news, and we're going to cover that now. We're going to turn real quick before we go to the federal case to talk about Tully, because I said at the beginning of the show, another one bites the dust, and that one's Tully. I mean, it's interesting when someone chooses to retire short of the amount of years you want to bank before your retirement is like fully vested and stuff. Like the way that government employees count down and calculate their retirement date to the day to maximize their retirements is something I am well familiar with. That it's not something that is taken lightly, especially if you're pretty close. If you're within like 5 years, if you're within 10 years, people are counting down their time. It is something that matters quite a lot. It's like, no. I worked in government. There is a retirement. The retirement is part of the consideration when taking a government job. That's part of it. So, Tully is retiring. Let's take a look. This is coming from NBC 10 Boston. I might have to change this immediately into reader mode because, yeah, I'm going to need it. We're going to need to change the technology a little bit so you can see the full article. It's been a minute. We've been in court trial so long that I moved everything so that we weren't dealing with websites quite the same way, because like it's going to just there. Former head of Massachusetts State Police unit that investigated Karen Reed retires. Let's move this back over. I hate the way this is formatted. And then put it in reader mode in a minute. Because the pop-ups, I love Kelly Clarkson, but the pop-ups, I am too ADHD for this amount of pop-ups. Massachusetts State Police Lieutenant Brian Tully, who oversaw the investigation into John O'Keefe's death and testified at Karen Reed's trial. Only trial 1, right? We didn't see him at trial 2, did we? I don't quite remember, honestly. Has retired. State police confirmed his retirement was effective at the end of the day, Wednesday. This article is from April 11th, so last week. Let's see. State police confirmed his retirement was effective at the end of the day, Wednesday. Tully's most recent post was part of the Field Services Division. An MSP spokesperson told the Boston Herald that that's where he had been reassigned to. I don't know what Field Services does. Feels like a desk. He formerly led the detective unit for the Norfolk County District Attorney's Office. Weeks after Reed's first murder trial ended, state police announced in July 2024 that they were investigating 2 troopers, including Tully, who testified at Reed's trial. Tully was transferred out in October 2024 after a new leader took over the entire agency. He was found to have violated department rules and regulations. Oh, you don't say. Oh, you don't say. And then I lost my place in this. He was found to have violated department rules and regulations. State police said in November that he had failed to supervise or discipline unit members, quote, who were involved with inappropriate text messages relative to an ongoing homicide investigation. Right. Given that, you can understand why failure to supervise is going to be part of Karen Reed's lawsuit against Massachusetts State Police. Tully was disciplined for that and forced to forfeit 6 days of accrued leave. Beyond that, state police did not give any further information on Tully's status at the time, saying only he was available to assist the DA's office with cases he was previously involved in. So he's retired. He will still come in and testify on cases that he needs to. We'll be hearing more about Tully as we cover other cases. But yeah, he lost 6 days of accrued leave for the failure to supervise that MSP is going to get sued for. We covered the fallout from the Reed case a while back when we looked at everyone who had been transferred, which was almost everyone that had been transferred. A number of officers had lost vacation days. We saw later that, well, Proctor gave up his appeal after he was terminated. We know that Good from Canton is still on leave, connected to the, believed to be connected to communications with Trooper Proctor based on the timing that all happened, which I covered, 5 months ago. I didn't even realize it had been that long. We saw that Dever quit from Boston PD. The fallout continues. The fallout has absolutely continued. And we will see more of it as we cover other cases in this jurisdiction because there are other cases pending. So, Somas said, is there any way to get him to lose his pension for this? No. No, they investigated and disciplined him. He lost 6 days of accrued leave. So no, he's not going to lose his pension over that. So we will see. Yeah. Pearl Snaps asked if I'd covered the Sandra Birchmore case. I have covered it on the podcast. We haven't covered it on stream. It's due for an update. Birchmore's also in federal court. So when it goes to trial, we're not going to be able to stream it, but there have been some pretty significant updates. So I will update it on the podcast. It's been a matter of timing. So yeah, we will be updating it because there were some pretty big updates in the Birchmore case. I haven't been covering it on stream. I've been covering it on the podcast, and it's not going to be a trial that is streamed that we can watch. So I will probably keep covering it on the podcast to let people opt in or opt out. It's a really tough case. It's just, when we talk about things being horrific, the Birchmore case just keeps getting worse and worse and worse. So did I see that Tully's fully vested at 20 years? I did not. So if he's fully vested, then there's really nothing that can be done. And maybe it was just his normal scheduled retirement date and there's nothing to see here. I don't know. Maybe there is, maybe there isn't. We'll see. But he's going to have to keep testifying in cases that he's already handled. So yeah, if he's already vested, then it might just have been that this is when he was planning on retiring. It could be a, nope, I'm out. But with any of this, I mean, he was investigated by the department and they took 6 days of accrued leave. That's what they decided was appropriate. So, yep. But Tully is now also retired, not resigned, not fired, disciplined for failure to supervise, but retired. And now, speaking of not retired and someone who would have, I imagine, lost their pension or at least lost parts of their pension, though the nuance of pensions and protections there is not my specialty. So it's, as we go to Proctor, I imagine that him getting fired had some impact on that. I just can't give you more in depth about what that impact is. I am not well enough familiar with MSP's policies and how long he was there to help with that. But I imagine there would be some impact. I'm not sure what it is. But there's other impact for Trooper Proctor. As we turn to the Karen Reed civil federal case, we need to do a bit of a road so far because it's been a minute since we've covered this. We did Karen Reed Sues Everybody a number of months ago. The original filing that we talked about this in context was a court hearing plus where Karen Reed, I think it was Alan Jackson, was talking in court about how in the wrongful death case, he was bringing in or wanted the court to bring in a whole bunch of cross defendants. So the O'Keeffes sue Karen Reed, and then in the same case, Karen Reed sues everybody else. And then they have cross defendants in the same case. And the court was like, whoa. We're going to have to have a lot of hearings to try to figure out if this is appropriate, if this is what serves this case best. Karen Reed's argument at that time was, look, this is part of our defense necessarily that in defense for wrongful death, it's that Karen Read didn't cause the death. That's part of her defense in the wrongful death case. And the argument from her attorneys being, because of all of them, it is our defense that they are responsible, not us. That's our defense in the civil wrongful death case. And yes, you can have a criminal acquittal and a civil finding of liability. So that was all playing out in the O'Keefe wrongful death case. It would have made that case kind of messy. It would have really made that kind of messy. Because it would have just pulled in so many other individuals into the case. Karen Read's team can still use the defenses that they are going to use without having all of the people at the home and MSP and everyone else getting sued in the same lawsuit. It doesn't deprive them of their defenses. So they were going to sue. They were going to sue in state court, and I think they filed the original one, and then they were going to litigate whether it would be allowed, and then it got removed to federal court. The procedural nuance of how that happened was months and months and months ago, and I do not trust that my memory of it is fresh enough, but it got removed to federal court either way. In getting removed to federal court, there was an amended complaint that was filed by Karen Read at the end of middle of last month on March 13th. We are not going to go through all of the amended complaint. If at some point we need to, we will circle back to it. But today we're not going to go through all of the amended complaint. I am going to go through who the parties are and what the causes of action are. But we know what these allegations are essentially. The allegations are that, well, let's let the document speak for itself, Emily. How about we just go to the document? How about we just do that? Yes. Also, for those of you that are like, it's very bright. Yes. It was not sunny all week, and it was sunny today, and I didn't close the blinds because the cats were over there this morning looking at the birds. So yes, the sun today is a whole different situation. We are turning now to the Karen Read sues them all federal lawsuit, taking a look at the amended complaint. A lot of you have questions, and I've seen a couple of them come up in the chat. Why federal? We'll look at what they say in jurisdiction in the complaint. We'll take a quick look at that too. So let's do that now. We needed to swoop a dupe. For sure. All right. Let's see. Amended complaint. This was from March 13th, 2026. Fun fact. This is docket number 54. It is also 54 pages long. I would not like to try to estimate how long it would take me to go through 54 pages of this document. Also, where did I put Emily? You were at a loss for lip gloss. I am. I keep forgetting to pull things back into the office from like my purse. ADHD. And then I sit down and I'm like, I don't have any lip gloss in here at all. So we're gonna hope that one doesn't get sticky. There's like approved and not approved. It's a whole situation. Textures, talking, all the things. This is the amended complaint. Karen Read versus Michael Proctor, Yuri Buchanan, Brian Tully, Canton, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins. Karen Read sues everybody. So this is, Miguelina, this is not the wrongful death lawsuit. This is Karen Read's lawsuit, federal lawsuit against the police and the House defendants, not the police department. All right. Amended complaint. For 3.5 years, plaintiff Karen Read was wrongly accused of homicide and subject to suspicion, arrest, 2 prosecutions, public condemnation, all resulting from the gross misconduct of MSP and those working in tandem with MSP to shield them from liability to shield them from liability, the party or parties. No, to shield from liability the party or parties responsible for the death of Boston police officer John O'Keefe. Now, after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for and address the actions of those actually involved in Mr. O'Keefe's death and the law enforcement officers who abjectly failed to ensure that justice was sought and served in the aftermath of January 29th, 2022. Right. So they really just set the stage. That is what they are. That is what they are suing over. Ashley asks, why no MSP? Are they immune? They are going to be sued separately. So the government entities will be sued separately. We talked about that just briefly when we were talking about Proctor's phone, that has not been brought yet. This is Karen Reed sues everybody personally. So this is not suing Buchanan in his capacity as a police officer. MSP will be sued for that. This is suing them personally. So we are going to not go through their introduction. We're going to go through jurisdiction. We know what these arguments are. We have seen Karen Reed's attorneys talk about these arguments quite extensively at this point. But we are going to look at jurisdiction. This was removed to federal court by the parties that were at the home. And if we want to go through this more fulsomely, I'll put up a poll at the end, and then we will go through this more thoroughly on a different day, because I do want to get to the Proctor motions, because I'm really interested in what was filed yesterday, and I'm a little antsy, and I didn't pre-read it, and I'm just like, I want to know. I want to know. Is this the whole civil case? Chloe J, no, this is one of the civil cases. This is Karen Reed sues everybody. Karen Reed also has the wrongful death case where the O'Keefes have sued her. Parties: Karen Reed, Michael Proctor, Buchanan, Tully, Albert Bryan, Albert Nicole, McCabe, Jennifer and Matt, and Brian Higgins. Jurisdiction: the court has subject matter jurisdiction over this case pursuant to 28 U.S.C. 1331 and 1364. This case was removed to this court by the defendants. So the defendants moved it to federal court under 1441. Let's see if we just need the language of 1441. Let's see if it'll help at this point, because I know that is a point of curiosity. What did I say? 1441. Let's see. We're going to pull up a side quest. We're going to side quest for a moment on jurisdiction. Yes, yes? Wonderful. All right. Diversity jurisdiction, federal jurisdiction, federal subject matter jurisdiction. Now I have to wiggle it just a little bit. Hold on. There we go. Joinder of federal law claims and state law claims. If a civil action includes a claim arising under the Constitution, laws, or treaties of the United States within the meaning of Section 1331 of this title, and a claim is not within the original or supplemental jurisdiction of the district court, or a claim that has been made non-removable by statute, the entire action may be removed if the action would be removable without the inclusion of the claim described in subparagraph B. Federal cause of action. Federal claim. That's why. There's a federal cause of action. We will look at the federal cause of action in this when we get to the claims. That is why they moved it there. Let's see, where did where did our amended complaint go? There it is. So that is why. This might not be wrong though. Samina Boys, no. Did I say that right? I don't think I did. Sim in the chat said, we moved it to federal court so it can't be streamed. That might be a consideration. They are allowed to move it to federal court because of the types of causes of actions that were brought. So we're going to take a look at those causes of actions real quick. But yes, Federal court will not be streamed. So that is part of it. Let's see. There we go. Trying to fix the screen. We're not going to go through the facts. Again, if we want to do this another day, it will take us probably an hour and a half to go through this entire amended complaint. Again, similar to what we have heard, I imagine more detailed. I have not gone through the entire thing yet. I can also go through the entire thing and summarize it as we cover the federal case more. We've been covering the wrongful death case more than the civil case. We're just going to causes of action to get footing for what is happening now in discovery. And if we need to jump back and review this, we will, if that's helpful. Counts. This is what we were looking for. Count 1, 42 USC 1983. Right. Civil rights violations. This civil rights violations, even though they're against Proctor, Buchanan, and Tully, the other defendants moved to remove this to federal court because there is a federal subject matter. You are allowed to move it to federal court. 1, the preceding paragraphs are incorporated herein. 2, Proctor, Buchanan, and Tully violated Ms. Reed's Fourth Amendment rights by engaging in a malicious prosecution of Ms. Reed by causing her to be seized pursuant to legal process unsupported by probable cause. The criminal proceedings against Ms. Reed terminated in her favor when she was acquitted of murder, manslaughter, and leaving the scene of an accident with a death. Proctor, Buchanan, and Tully caused Ms. Reed to be seized without probable cause as described above, including but not limited to. So this is the malicious prosecution, essentially. No, Emily, it's literally titled the malicious prosecution, but we're under our 1983 rights in the federal code. For you to bring a malicious prosecution claim, the claim has to resolve in your favor. So that is going to be one of the arguments I imagine going forward as we get into motions to dismiss and the rest of it. And maybe that's the time to summarize this as we get into the motions to dismiss. That might be cleaner because motions to dismiss are already starting to get filed, that we kind of go through the summary of this then. But this is your malicious prosecution section. There will be more. These are the federal claims that tie this into federal court. They go on to say that the without probable cause includes leading, handling, and participating in the O'Keefe investigation, even though Proctor was conflicted due to personal relationships with various witnesses, suspects, and potential suspects, which conflict led to Ms. Reed's unlawful treatment. Handling the investigation, even though Proctor had an extreme and personal negative bias towards Karen Reed, which bias led to Ms. Reed's unlawful treatment. Violating MSP rules, policies, and procedures in all aspects of the investigation. Planting, fabricating, and manipulating evidence, falsifying documents, preparing false affidavits, and committing perjury. Oh boy. Failing to secure evidence at the crime scene, obtain evidence, timely and appropriately interviewed suspects, and investigate the Alberts, McCabe's, or Higgins for allowing them to destroy potentially exculpatory evidence. Failing to consider and present exculpatory evidence to prosecutors and the grand jury investigating Mr. O'Keefe's death. Yes, you have to do that. At a grand jury, you have to also present exculpatory evidence. Let's see. Failing to consider and present exculpatory evidence to prosecutors and grand jury investigating O'Keefe's death, such as the evident dog bite injuries on Mr. O'Keefe's arm and evidence that his injuries were caused by an altercation and not a vehicle strike, such as the lack of lower body trauma. Following her indictment by grand jury, Reed was rearrested without probable cause, forced to pay a $100,000 bond to be released from custody, and required to comply with numerous pretrial release provisions. These post-arraignment deprivations of her liberty constitute seizures under the Fourth Amendment. Those deprivations continued during Reed's second trial, in part because of Proctor's false testimony at Miss Reed's first trial. The font changed on that sentence in an odd way. Either way, sorry, it made my eyes go like, whoa, what's happening? The sentence goes on to say, among other things, Proctor falsely testified that A, when he first saw the taillight on Miss Reed's car at Miss Reed's parents' house in Dighton, it had large pieces missing, and the shattered taillight displayed at the first trial, as photographed February 1st, 2022, was in the same condition as on January 29th. He and Buchanan never touched any part of Miss Reed's vehicle when it was stored in the CPD Sallyport. He retrieved taillight pieces on subsequent searches at the Alberts home when he knew he had deposited or arranged for someone to deposit taillight pieces at the property. Again, allegations and shade in a federal suit, but this is what they're saying they think they can prove if this goes to trial, that they are going to prove that Proctor did these things. They go on to say Chris and Julie Albert were his loose acquaintances rather than his friends. I think that's going to be fairly easy to prove. His statements and sworn affidavits all claim the Lexus was seized at 5:30 p.m. and that he arrived in Dighton at 4:30 p.m. and that they were typos. It goes on to say, thus, Proctor, Buchanan, and Tully, acting under color of law, violated Miss Reed's Fourth Amendment rights against unreasonable searches and seizures. As a proximate result of this misconduct, Reed was wrongfully prosecuted for O'Keefe's death and made to defend herself in 2 trials in the Norfolk Superior Court for Norfolk County, resulting in the loss of employment, reputational damages, millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. I don't doubt any of that. In addition to an award for damages of these harms, Ms. Reed is entitled to her attorney's fees. Whoomp, there it is. Under 42 USC 1988, costs, interests, and punitive damages. That's your potential multi-million dollar reward. Remember, as we've talked in other cases, including the TikTok psychic case, as we've discussed in other cases, if the attorney, arguendo, if Alan Jackson looks at Karen Reed and is like, look, I'm not charging you attorney's fees for trial number 2. We heard Alessi discuss this. I'm not charging you for attorney's fees. Our firm's gonna take care of that. That does not stop them from seeking attorney's fees from these parties. Alessi's firm can add their attorney's fees to this pursuit of attorney's fees, even if they were not charged to Karen Reed. They don't go back to Karen Reed's pocket. They go back to the firm to make the firm whole for the work that they chose to do. Just because an attorney might give a discounted rate, might not charge for every hour of attorney's fees, they will still track it and they can still pursue it. So even if they're not going to pursue Karen Reed's pockets for some of these fees, they can absolutely go after these defendants' pockets. Yes, they can. So I hope that that's a helpful answer to a what if. I talked about it most recently in the TikTok psychic case because I was surprised that the attorneys there had reduced. I was not surprised they had reduced their rate for the professor. I was surprised that they didn't go to recover their full rate from the TikTok psychic, which they could have. So the attorneys that worked for Karen Reed, Yannetti, Alessi, Jackson, Little, all of them, they can all seek to recover their fees here. It's going to be a lot of fees. I'll be really curious how many millions, but yes, they can go after that. However, they can also go after that from MSP, which probably is in a better position to pay it, and Canton, maybe not in as good of a position to pay it. They can go after it there too, and then we'll get into joint and several, and who pays and who doesn't. Like, they're not going to be able to double dip from both parties. They're not going to be able to get 2x their attorney's fees, but they will be able to seek their attorney's fees from these parties and from the government entities if they sue them. So multi-millions. Hopefully that makes sense. Count 2, supervisor liability under 42 USC 1983. They go on to say a supervisor is liable under 42 USC 1983, where the supervisor supervises, trains, or hires a subordinate with deliberate indifference towards the possibility that the subordinate's deficient performance will result in a deprivation of an individual's constitutional rights. Right. It goes on to say that Buchanan and Tully knew or should have known that there was a grave risk that Proctor would fail to investigate the Alberts with whom he had a close personal relationship, which he had disclosed. How much did he disclose? Like, how much did he disclose? And do we see why the phone becomes such a big deal? They also knew or should have known that there was a grave risk, not grave concerns, grave risk, Proctor would wrongly seek to have Miss Reed charged given the manifest bias evidenced in his text messages, which were sent to Buchanan, among others. Buchanan and Tully could have taken easily available steps to avoid constitutionally deficient, malicious prosecution of Miss Reed. Those measures include literally pick anybody fucking else. Pick anybody else. Sorry, that was my summary. Literally pick someone else. It's MSP. If it's too small town, grab somebody from the other side of the state. It's the state troopers. I don't know. Go get somebody from Worcester or Andover or whatever. Just pick someone else. You know, go to Amherst. There's got to be people out there like keeping the college kids in line. It feels like the other fucking side of the state. Go grab somebody that didn't grow up with everybody. It's not going to be that hard. That's not what they wrote. They said these measures include, 1, replacing Proctor with an unbiased investigator that had no personal relationship with anyone involved. Shocking. You're the state troopers. Grab a statey. 2, safeguarding the crime scene and physical evidence, including O'Keefe's clothing. Shocking. And 47 pieces of taillight material and 19 pieces of glass from various sources to prevent anyone from planting, manufacturing, or manipulating evidence. Wow. Handle the evidence properly. Shocking. Pearl Snap said EDB knows how to say Worcester. Look, I mispronounce lots of things unless I have heard them pronounced, but I went to UMass Amherst. So I learned things in my time at UMass Amherst. So I know some things, but not all of the things. I am a fan of Mass. I'm not a Mass native. I'm not a fan of any of this fuckery. This is wild. But I'll be adjacent to everybody's rage about it. I'm here. I'm here to be like, you're not wrong. This is insane. What are we doing? This is not how things happen. You have every right to be mad and to request better. All right. So, get a non-conflicted investigator. Handle evidence properly. 3, initiate timely searches of the Alberts' house. 4, quickly seizing the cell phones and other forms of electronic evidence in possession at the Alberts, the McCabe's, and from Higgins, which would have prevented their later manipulation and destruction. They weren't destroyed. Oh, say something since EDB just said she's not a masshole. No stolen valor, no stolen mass valor. I just want to be clear. I'm not local. I'm adjacent. That's got to be earned. I was not there long enough to earn it. It was a layover. But can you pronounce Peabody? Isn't it Peabody? Let me know if I got it right. But if you start questioning me on all of them, I'm definitely going to fuck some of them up for sure. Let's see. That was all. The manipulation, the yeeting of the phones, the wild yeeting of the phones. There are a few that I will always mess up, though, every single time. So, continuing with that. Where are we? Yeah, don't yeet the phones. Right. By not taking any of those measures, Buchanan and Tully permitted Proctor, and Tully permitted Buchanan to violate Reed's Fourth Amendment rights. In these ways and others, Buchanan's conduct constitute. Shit. In these ways and others, Buchanan's conduct constituted coordination. Who wrote this? And did you giggle at how hard this would be to read? Because I feel like you put this sentence on hard mode. Buchanan's conduct constituted coordination of or acquiescence to Proctor's behavior or gross negligence. In these ways and others, Tully's conduct constituted coordination of or acquiescence to Buchanan and Proctor's behavior or gross negligence amounting to deliberate indifference. By proximate cause, Reed was wrongly prosecuted. They say that in addition to the award for damages, Reed is entitled to attorney's fees. Count 3. Conspiracy to deprive Reed of her Fourth Amendment rights against all of the defendants: Proctor, Buchanan, Tully, Alberts, McCabe's, Higgins. Everything's incorporated above. We are not going to go through all of it because we have 2 more motions we need to go through. But that they were all involved together in not coming forward. That's what this allegation is broadly. We'll do this one paragraph. Proctor, Buchanan, and Tully knew or should have known that the statements made to them by the House defendants were false and that obvious and easily obtainable evidence existed demonstrating that O'Keefe went into the house where he was involved in a physical altercation during which he was beaten up, fell back, gashing his head, and attacked by a dog. Instead, because of their close personal and professional ties to the House defendants, Proctor, Buchanan, Tully agreed with each other to use the House defendants' misrepresentations as the predicate for an implicit direction to conduct an investigation that solely targeted Miss Reed to the exclusion of everyone else. The only reason, Catherine, that I can say Saskatchewan is because there was a boy. That is the only reason. That is a story for another day. Probably members only. That is the only reason. It is not because I have a phonemic awareness. It is just life experience. That is the only reason. Yes, he played hockey. College. It was college. Continuing on. Let's see. Look, Proctor, Buchanan, and Tully all just went, yeah, that sounds reasonable. We don't need to ask anybody in the house. He never went in the house. It's all fine. It's all fine. It's all good. That's the basis of this, that the House defendants lied, that all of the law enforcement officers went, yeah, sounds fine. It's all good. And that deprived Karen Reed of her rights by continuing to prosecute her. This is an incredibly long statement of facts, but they're asking for an award of damages, including attorney's fees, cost, interest, punitive damages. Count 4, Massachusetts Civil Rights Act against Proctor, Buchanan, Tully, the Alberts, McCabe's, and Higgins. That those defendants interfered or attempted to interfere with Miss Reed's exercise or enjoyment of her rights under federal and Commonwealth constitutional law through threats, intimidation, or coercion. So that is what count is that. Count 4. Count 5. Common law malicious prosecution. We just talked about this on the podcast, right? On the podcast, Ashley in the chat said, shall we start on Washington State? Okay, I was only at Seattle University briefly. So I am, the further out from Seattle we get, the worse I am. But it took a minute when I moved there too, especially with like Snohomish and stuff. It took a minute. You just got to talk to the locals. So, but briefly, no, if I haven't lived somewhere, I'm totally screwed. In the common law malicious prosecution, we just talked about this on the podcast. There are two causes of action here. One for malicious prosecution under the federal law and one for malicious prosecution under state law. We look at very few cases do we ever get into like the nitty gritty, like legal treatise of why choice of law matters, why the different causes of action you bring matter. In a lot of criminal cases, you've got multiple causes of action and they're different theories. And though you can be found guilty of all three of them, you can't be penalized for all of them. We're in like a similar but different circumstance with civil, that you've got different grounds for malicious prosecution under different laws, which can matter as you get into motions down the road, as we saw just recently in Lively Baldoni, where there were a lot of different causes of action under different areas of law. And the court went through an entire evaluation of, this is why you can't do it under federal law. This is why you can't do it under state law. And that's why lawyers going through pleadings craft them this way, so their bases are all covered, essentially. And that's why we will see that in civil cases, particularly because you've got to get through all of your motions to dismiss and your motions for summary judgment. And then you can narrow it down when you go to trial if you want to. But if you don't plead it at the beginning, you can't add it in. So you throw it all in at the beginning and then you narrow it down before trial. Hopefully that makes sense. So we've got the common law malicious prosecution that includes the Alberts, McCabe's, and Higgins. Notice under the federal malicious prosecution, they did not bring in the non-law enforcement individuals. Here they brought in the non-law enforcement individuals under the state law. And it might be that they choose to go forward with the common law malicious prosecution because it seems that they can bring in the Alberts, McCabe's, or Higgins. Maybe they can't. Maybe it will get yeeted down the road, but maybe Massachusetts allows for the individuals that cooperated with police to also be sued for malicious prosecution, which would actually be an interesting difference between Massachusetts law and federal law. So they've pled it here. The motions to dismiss have already started getting filed, so we will get there in due course of covering this case. But it's an interesting quirk, and I appreciate the pleading because I didn't even think about whether you could sue the non-law enforcement civilians for malicious prosecution under, let's see, under common law in Massachusetts. That would take a bit of research. I'm going to wait to see how they argue it in the motions to dismiss. I'm curious. I'm really curious about that one. Count 6, intentional infliction of emotional distress against all the defendants. I mean, is there a question now, whether it was intentional or not will be a question, but is there any question that this caused a significant amount of emotional distress? I mean, I don't think that I think that that's true, but they go on to talk about the suit for the IIED against all parties for the injuries to Karen Reed in that way. And the proximate result of all the defendant's action, Miss Reed suffered serious emotional and physical distress and injury. Right. Count 7, civil conspiracy. Y'all agreed. A civil conspiracy is an agreement to do a thing. Y'all agreed. So civil conspiracy, that's going to be under state law, though they don't cite which law they are. I have a question about the civil conspiracy claim, but that might just really be a theory of liability and not a separate cause of action, which we see in a lot of jurisdictions. But that might just need to be pled as hey, the reason we're suing everybody for everything is because they all agreed. I don't know if there's a separate cause of action for civil conspiracy in Massachusetts, but I'm not a Massachusetts lawyer, so don't take my word for it. There may be, there may not be. That one gets an asterisk of things Emily wants to look into further. Not super relevant for today's conversation. Let's see. Jury demand. Yes, a jury trial. Of course, yes, a jury trial. And then their prayer for relief, judgment in Karen Reed's favor against all defendants. award of damages calculated at trial along with pre and post judgment interest, costs, and expenses, reasonable attorney's fees, other such relief. That's your basic damages. We see that we've got both law firms on this, Alan Jackson's firm, and then Damon Seligson is the other attorney representing Karen Reed that we've seen at some of those hearings. All right. Are we ready to look, now that we've gone through how many causes of actions? Emily, did you already forget? 7. The 7 causes of action against Proctor, Tully, Buchanan, the McCabe's, the Alberts, and Higgins. All of those causes of action in the federal case that got removed to federal court, because some of the causes of action are based on federal law under 1983, including the malicious prosecution. Those causes of action are separate and apart from Karen Reed getting sued in the civil wrongful death case. In this case, we have the beginnings of people answering complaints, initial motions to dismiss. Discovery is going to be beginning. And in that context, there is a very interesting motion from Trooper Proctor. I am not going to go through the notice of the motion. We are just going to go through the filing. This was filed on April 10th. So we are getting kind of caught up in time. We will go back and look at those motions to dismiss and things in due course. But the response to this was filed yesterday. And the audacity. Also, this is docket item 67. So, docket 67. Defendant Michael Proctor's memorandum of law in support of his motion to conduct limited discovery to third parties prior to the court's establishment of a Rule 16.1 and Rule 26F conferences. Buckle up. For those of you that are like, what does this mean? Just wait. Just wait. What does Proctor want? Proctor submits this memorandum of law in support of his motion to conduct a limited discovery prior to the court's establishment of the Rules 16.1 and Rule 26.f conferences. Don't worry, we'll get there in the motion, or we should. Specifically, Proctor seeks leave of the court to serve the attached 2 keepers of the records subpoenas on the Norfolk County District Attorney's Office and Canton Police. Proctor wants discovery from the Norfolk District Attorney's Office and Canton Police Department. As grounds, Proctor states that good cause exists to allow this motion, as he is scheduled to be deposed as a witness on June 8th in a parallel case pending in the Plymouth Superior Court. It's so frustrating when we don't get discovery, isn't it? Wasn't Proctor just in court objecting to discovery, being like, oh, they don't even go here? Why aren't you filing this in the civil wrongful death case? Oh, because you're not a party in the civil wrongful death case. So you want to come up in this federal court and be like, hey, Your Honor, can I go ahead and use the subpoena power of the federal court to get documents to prep for a deposition in a not this case? It's a not this case. You want to prep for your deposition in not this case. Go ask that judge. Why are you asking this judge? You want to go complain in the Miles King case that she doesn't even go here, and why is Karen Reed coming up in here asking for the phone discovery that's governed by that court? And you're asking this court that does not govern the processes in that court, asking for discovery to prep for your deposition. Okay, boo-boo. Let's see how that goes. Cause what? Good cause, he says, exists to allow this motion because he's scheduled to be deposed in a parallel case.
Bruh.
You're not being deposed in this case. Are they connecting the depositions so that you're only going to be deposed once, or are they going to depose you again in this case? Does the deposition cover both cases? Maybe I crashed out preemptively. But that's not what you said. You said scheduled to be deposed in the wrongful death case. Maybe keep reading. And plaintiff's counsel, who represents Miss Reed in the state court case, has refused to provide Proctor with sufficient material with which to prepare for that deposition. What? But Your Honor, Karen Reed's lawyer won't give me discovery. Oh boy. Do you think they have to? Like, are they never mind. See Exhibit 1, the April 7th, 2026 email from plaintiff's counsel. Here's the only question. Do we jump immediately to the email and then come back? Or do we just keep reading and get to the email at the end? Option 1 or 2, chat. 1, we do it now. 2, we do it at the end. Pop it in the chat. We'll go by vibes. Indeed, Miss Reed's refusal to assent to this motion underscores the necessity that the court allow the same. That's a lot of ones in the chat. It's a lot of ones in the chat. All right, vibes win. We'll jump ahead and read the email. But literally up in this motion saying they were disinclined to acquiesce to his request for discovery ahead of his deposition. Miss Reed's refusal to assent to this motion underscores the necessity that the court allow the same. Let's jump to that email real quick. I'm going to spare you all the super scroll. It is not too many emails. It looks like it's 2. All right. Well, I think we got to start from the bottom and then we're here. Nope, wrong one. This one. Let's see. That's 4-8. This is 4-7. All right. This is on 4-6. Great. Started from the bottom. Now we're here. This is from Matthew at law firm. These are all law firm email addresses. Here, let me fix that real quick. Regarding Proctor deposition. Aaron, confirming that I may accept service of the subpoena on behalf of Michael Proctor. On a related note, we have previously inquired whether you would be willing to share the documents produced thus far in the O'Keefe versus Reed matter in advance of Proctor's deposition. You indicated you were not obligated to do so and were not inclined to do so. Can you please confirm that that remains your client's position? Thanks. The wildness of Proctor reaching out to Karen Reed's attorneys and being like, hey, can we get all of that discovery so we can prep for a deposition of Proctor in the civil wrongful death case? Thanks, that would be great. Y'all, how did these lawyers expect there to be any other answer than no? I mean, I would expect it to be a more vociferous and cursy no. I imagine that happened behind the scenes. But the turn of events that have landed us with Proctor being like, hey guys, I can't prepare for my deposition because you won't give me the discovery. Maybe it's with a rehomed phone. Because when they came to ask you for your phone, it was just like, oops, there's no phone here. Maybe go subpoena the district attorney's office. Perhaps. Just go subpoena them. Weren't you just objecting to Karen Reed getting discovery that she already fucking has to use in another case? You were objecting to that, right? Right. Civil law is a different level of petty. Also, wasn't it you specifically, like Proctor specifically, that in the Miles King case didn't turn over a search warrant for like 5 fucking years? They'll get back to you. I'm sure they'll get back to you. It's probably on a hard drive somewhere. I am sure they'll get back to you. But they're busy. Go ask the district attorney's office for it. Maybe Lally will just get back to you on that. Oh, it's so annoying when you don't get discovery. Oh no. Whatever would that be like? I don't know. I think code bruh is where we have to go, because I understand the legal grounds for his lawyers to ask for this. The only reason this is funny is because karma. Because of the history here, this is hilarious. In other circumstances, like a retired coroner going to the coroner's office and being like, hey, I've got to prepare for this trial. Can I have access to my old file? Is not weird. Like, there are circumstances where this is not strange. So it's not full audacity, because it's a reasonable request. It's just the fucking karma of, I would sure love to have some discovery, but Your Honor, they won't give it to me, I think lands us in code bruh. I think that's where we land. So for now, we're going to grant code bruh, and then we'll see where we get. We might cross into audacity. We truly might get there. We might not. I don't know what's going to happen. I did not read these motions prior to stream. I saw that they were on the docket. I saw the title of what was filed yesterday and went, oh boy. And then I put them in my file and I backed away so that I would not pre-read them without y'all getting my unfiltered, very ADHD stream of consciousness thoughts on what the fuck are we even doing, asking the federal court to force discovery in the civil court after we just read Proctor trying to block Reed from doing the fucking same thing in another case.
Bruh.
So your motion for code bruh is granted. Also, when I talk about the fact that lawyers can be petty, there are a lot of rules. There are a lot of rules, particularly in criminal court, that protect people's rights, which is necessary. When you get to civil court, the rules are very different. And civility is not the jumping off point necessarily, especially if there's some bad blood between the parties. So if the rules do not say you shall do this, well, then yeah, I'm disinclined to acquiesce to your request. I don't have to do that. And in fact, most lawyers are going to go with, yeah, I have an obligation towards zealous advocacy, and I'm not going to help you not wreck yourself. That's not me protecting my client. No, we're not just going to sharesies the discovery. Go get it from your former employer. Good luck with that. You can see what it's like to try to request discovery from MSP and the Norfolk DA's office. Have fun with that adventure. I wish you the best day possible. Enjoy. Bonsoir. Like, goodbye. Aloha. Like, what? Go away. So no, they're not obligated to do it. They're definitely not going to find a way to just helpsies out. And if lawyers want to help one another in a case and it benefits their client to do so, they can choose to do so. But yeah, they don't have to go above and beyond. No. They have to be civil, like minimally polite, but no. And when we have seen the level of interactions in the civil case, remember the whole reply to all debacle? We're not even at professional courtesy in the civil case, where, side note, just like footnote. Remember in the wrongful death case where Karen Reed accidentally replied to all, which I'm sure she will never, ever again do in her entire life, but accidentally replied to all and it went to the O'Keefe's attorney. And then her attorneys reached out like 45 minutes later and were like, hey bro, so our client accidentally responded to all. Like that shouldn't have happened. Our bad. It will never happen again, but can you just go ahead and delete that? And the O'Keefe's attorney was like, yeah, no, I'm disinclined to acquiesce to your request. I'm not going to do that. And then they had motions and a fucking hearing on it, because the professional courtesy is generally that when it's clear that it's an error, you never know when it's going to be your client on the flip side of that coin, and you just delete it. But no, they had to go through an entire motion process and hearing to make the other party delete the email. And they're like, no, why should I do that? Right. That's where we're at with these cases. I don't know why Proctor's lawyers coming all up in here thinking they're special, because that's not going to go well. That's not going to go well. Either way, we're at code bruh. So let's go ahead and grant the code bruh. We have a new code bruh bumper. So enjoy. Code bruh. Motion granted. Bruh. And yes, the bruh is Griffin. A lot of you were on stream that day when we were talking about another case, and his response to it was in fact that. So we clipped it from stream to turn it into our code bruh. So, code bruh, because what are we doing? What are we doing with this motion? Let's find out. All right. Excuse me, Karen Reed attorney? I'm Proctor attorney. Can you just share the documents discovery in the O'Keefe matter? It'd be so great. It'd be so great. It'd be so great. But you said you weren't inclined to do that. Is that still your position? Or not? Or yes? Or not? Maybe? So then the next day, the response is, Matt, this is regarding Proctor deposition. Matt, thanks for accepting service. As you know, there is no obligation by rule or other law that requires a party who notices a third-party deposition to provide discovery to that third-party witness. Frankly, I've never had a third party request that. Bruh. I've never had a third party request that. Putting that aside, practically speaking, there is a massive amount of information easily accessible to you regarding this case online. Oh my God. What's the date of this email? We're side questing again. What's the date of this email? The date of this email is April 2nd. Hold on. Where is that last motion by Proctor where Proctor was like, but Your Honor, there's already a massive amount of information online, and they can just go get it online. And if we give them the phone extraction, then it's gonna fan the flames. Your Honor, we didn't start the fire. Your Honor. Hold on, I gotta go find it. Where's the other one? I have too many files open. It's probably here somewhere. Wait, where is it? Here it is. All right. This motion. What did Proctor say? Proctor said, well, what did he say? Furthermore, this is Proctor's response in the other case. Furthermore, the internet is already rife with information data concerning Miss Reed's trial. God, I wish they had quoted it directly. Next time, can we quote it directly? Excuse me, Matt, the internet is rife with information data concerning Miss Reed's trials. You can just go get it there. Then they should just put Turtle Boy's Twitter handle. Just go grab it. Reddit, something. This motion was dated March 27th. That's what I wanted to see. March 27th is when Proctor's attorneys, in opposing Karen Reed's request to use discovery she already fucking has, said, but the internet's already rife with data. March 27th. So in this April 7th email, Karen Reed's attorneys respond with, frankly, I've never seen a third-party request this. So weird. Putting that aside, there was a massive amount of information easily accessible to you regarding the case online. The internet is rife with information about this case. Why don't you Google it? Publicly speaking, there is a massive amount of information easily accessible to you regarding this case online, including almost all trial testimony. Yeah, all the trial testimony except for John O'Keefe's niece and nephew from 2 trials. Exhibits admitted in the criminal trials, various police reports, and various pleadings and filings in this matter and the federal court case, setting forth in detail all the claims made by almost everyone. Shit's online, buddy. Outside of protected attorney-client and or attorney work product information and documents that I'm restricted from producing to you by various protective and court orders, I'm not sure there is much that I could possibly send to you that isn't already in the public form. Sorry, buddy. I don't know what I could possibly send to you that you can't just go find for yourself. Go watch all the videos. Some are longer than others, but they're all there. Your client can watch. Your client doesn't even have to go pay for transcripts. Your client can go watch back his own testimony. That is a rare and unique circumstance. So, surely there's nothing left. I'm not sure that there is much I could possibly send to you that isn't already in the public forum. It would be a difficult and extremely time-consuming task for us to conduct a review to isolate what we're able to provide to you in advance of the deposition and what is and is not already available to you, and then produce some subset of documents to you. This would be particularly burdensome because we are currently engaging in extensive discovery between the parties with upwards of 20 upcoming depositions and an August discovery deadline. Good luck to you. We're booked and busy, boo-boo. And we're still fighting motions in court over your phone that was lost multiple times. Funny that. Oopsies. So we're busy. Finally, if we provided some but not all of the documents to you, we are concerned that we could create trial issues that would not otherwise exist, particularly where no rule contemplates a production like this. For those reasons, I think we should handle this deposition just like all the others, under the rules of civil procedure. Thanks, Aaron. Aaron! Look, Aaron, I have a few questions. Maybe one day you'll be able to answer them. What's the spicy version of this email before you translated it into lawyer? I want to know what the spicy version was. Did it start with, you dumb motherfucker, or no? Is that too much at the beginning? Or maybe you went like full just, I could just see you next Tuesday and then we could figure it out from there. No, too much. I would say maybe you just grab some of the direct language from his text messages, but that might be too offensive to send to another lawyer. And you probably could get sanctioned if you sent some of the things Proctor said in his texts to Proctor. You probably could get in trouble if you used some of the language he used and sent it to his attorney. It would be funny, but probably ill-advised under the professional rules. Did you contemplate just sending back like nuts, period? Not that I'm saying this isn't brilliant. This is wonderful. We've translated this very well. But I want to know what the first thoughts were before we translated it into professional snark. Because the level of professional lawyer snark, and again, this proves that the law nerds are never wrong, because jumping to the emails was far better than anything they're going to write in this motion. Because what do you mean? What do you mean there's no rule governing this? And then this is, I'm so glad we covered the other ones first. I'm so glad we covered the other ones first. Sometimes it just all works out, because this is infinitely funnier for the Proctor response in the other case, where this is not nearly as funny without knowing that Proctor in the other case is like, but the internet's already rife with information, to turn around to Karen Reed's lawyers looking at Proctor going, the internet's already rife with information. Oh boy. Oh boy. Yeah. Do you just put on like some Limp Bizkit and just type this out and then edit it back into professional? I love this so much. I love this so much. Yeah, we're not obligated to do that. You can go look on the internet. Also, we don't have the time to parse through all the discovery that you want to find what's even appropriate to give to you, because nobody fucking asks for this. Go get it yourself. Go get it yourself. Good luck with that. Yeah, I hope this email finds you well. Have a good day. Bye-bye now. Bye-bye. Bye-bye. Right. There's a response from, let's see. No, from Aaron again on the 8th. Tom, please send over the motion you plan to file in the federal proceeding, which we discussed on the phone this morning, when it is ready, and we will consider it and let you know our position. Our position is nope. So that was the meet and confer part of it. Hey, we're going to file a motion and ask the federal court to do this. And then they sent over the motion. They were like, yeah, no, we're not doing that. We're not doing that. I'm really glad we jumped to the emails. Let's get back to the beginning of this motion. We're going to just jump back into the filing a little bit and just kind of reset where we're at. But talking about the internet being rife with information in one motion, to only have it come back and slap you in the face in another motion is just a hilarious comeuppance. Oh boy. Oh boy. All right. Back to the federal court. But Your Honor, Proctor has a deposition on June 8th and they won't give us the discovery. Oh no. Oh no. I can't. Filing this motion is such an interesting choice, because under what law are you going to compel the attorneys on the other side to help you prepare for your deposition? And they raise a very valid point, and really wonderfully veiled snark, but they raise a very valid point. If we don't give you a document you think you need, you're going to turn around in trial and be like, see? They didn't give us everything. There should be sanctions. Why are we creating problems that don't exist? Exactly. Your Honor, there's good cause. He has a deposition. Oh no. Okay, so Proctor wants Karen Reed's attorneys to turn over their discovery from the civil case so he can prep for his deposition in the civil case. And instead of asking the court in the civil case, somehow he's asking the court in the federal case that doesn't have any jurisdiction over the civil case. Go ask MSP. Go ask the DA's office. You know, maybe it's with the rest of the video from the Sally Port. Hopefully they find it for you. It would be great if they found it for you. Maybe they will. Maybe it's with the evidence logs of when John O'Keefe's clothes went into evidence. Maybe it's there. Check there first. Put it in your subpoena. Just a thought. Getting back to this, they go on to say that plaintiff's counsel, who represents Miss Reed, has refused to provide Proctor with sufficient material to prepare the deposition. See the April 7th email from plaintiff's counsel that is hilariously good, just 10 out of 10. Indeed, Miss Reed's refusal to assent to this motion underscores the necessity that the court allow same. I hate everything about that sentence, but Your Honor, they refuse to help us. Help, Your Honor, help, help. They won't give us discovery. I just picture the defense bar in the area of Norfolk and Canton. I just picture the defense attorneys looking at all of this and laughing and being like, oh no, Proctor can't get discovery. Oh, that must suck. We know. But you go to sleep at your house every night while you're fighting for discovery. Our clients don't. So, where is it? Hold on. Your Honor, I don't remember what I did in this investigation or what I said or who I said it to or what my texts are because I lost my phone, but then they found my iCloud. And I need Karen Reed to just give me the discovery about the things that happened in this case because I just can't remember or keep my stories straight or remember. I'm not quite sure what's in my police reports because, I didn't file them for like 2 years in some cases. And it's just so hard to remember, Your Honor. Please. I need my discovery. I can't prepare for my deposition. Alan Jackson's going to get to grill me for like 6 hours. Oh no. I'm so sad. It's going to be so hard. How hard did Alan Jackson giggle while pouring himself a whiskey reading this? Oh, poor you. Reed's refusal to assent to this request. Fuck off. Come on. You're not entitled to it. They're not required to give it to you. They're not going to give it to you. In the words of En Vogue, never gonna get it, 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 never get it. Yeah, I can't do the rest. I am not a skilled singer. You can do the woo 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 part I can't do it. Yeah, you're not gonna get that. They go on to say it is essential that Proctor be provided access to documents within the DA's office and Canton PD's possession. Good. Go subpoena them. Go subpoena them. Go get it from the DA's office. Go get it from Canton PD. Why are you asking Karen Reed's lawyers for it? They got shit to do. Who's going to pay for the billable hours for them to go parse through discovery for you? You? No. Go ask the Norfolk DA's office. How does this even follow? It's essential that Proctor be provided access to the documents within the Norfolk District Attorney's Office and Canton PD's possession, custody, and control in order to refresh his memory prior to his deposition and prepare for the same. Go ask them. Oh, but you can't use the federal court subpoena to do it. You're going to have to go ask the state court. What day is it? Oh, no, it's boo-boo. It's April 14th. You better hurry. You got to go ask the state court. You got to go ask the state court if you can get a subpoena for that. Because the federal court's not going to give you one. So you're going to need a motion to intervene first. And then if you're granted leave to intervene, then you're going to need to ask for a subpoena. And then you're going to need to see if Canton and the Norfolk DA's office provide that in a timely fashion for you to prepare for your deposition. Sure. Okay, go ask them. Right. They go on to say no party will be prejudiced by allowance of this motion. they're going to have to spend the time to give you discovery. I think that's prejudicial. It is a waste of resources and time. Why would they waste their time? Why would they waste their time? I wouldn't even ask a law clerk to do this. Why would they waste their time? They have other shit to do. Factual background. This matter arises out of the January 29th, 2022 murder of John O'Keefe, which received extensive media coverage. Why is that the first sentence? Which received extensive media coverage over the past 4 years. And Mr. Proctor was assigned with other members of the Mass State Police to investigate the murder. Physical evidence collected at the scene, damage to Miss Reed's motor vehicle, statements made from eyewitnesses, and statements from EMT staff that Miss Reed, we're still there then, huh? That Miss Reed admitted to striking Mr. O'Keefe with her motor vehicle, combined with other evidence, established probable cause to believe that Miss Reed had struck Mr. O'Keefe with her vehicle while under the influence of alcohol. So did video footage. It's a bold argument. So did video footage and testimony of various bar patrons that showed Miss Reed drinking at least 9 different alcoholic beverages on the night in question. I agree that Miss Reed was drinking. Yep, I agree. That I can agree with. Miss Reed was shown on video drinking. I struggle with the rest of it, but if I start fighting over the statement of facts and the factual background from Proctor's point of view, we will never get anywhere. Plaintiff's amended complaint alleges that Miss Reed was arrested pursuant to a criminal complaint charging her with manslaughter, among other charges. That's true. A grand jury later indicted Miss Reed for second-degree murder, manslaughter, and leaving the scene of an accident resulting in death. After a hung jury was declared following her first criminal trial, the Commonwealth tried Miss Reed again. The jury in the second trial acquitted Miss Reed of murder, manslaughter, and leaving the scene of an accident resulting in death. Right. Why does it say in her second criminal trial again? Proofreading is just okay. However, the jury did convict her of operating under the influence of alcohol. The taxpayers spent how much on a DUI case, right? Proctor is scheduled to be deposed by Miss Reed's attorneys in the state court case on June 8th. Whereas Mr. Proctor is no longer employed by the Massachusetts State Police, he lacks access to all the documents and evidence arising out of the 2 criminal prosecutions of Miss Reed. Oh no! Go subpoena them! Oh! Moreover, Proctor's counsel has requested that Miss Reed's attorneys provide Mr. Proctor documents sufficient to refresh his memory in advance of the deposition. But Miss Reed's attorneys have refused to do so and stated they have no obligation by rule or other law. Yeah, they said fuck off, but like nicely. We don't have to. We are disinclined to acquiesce to your request. The internet is rife with information on this case, as you yourself have so stated in other venues. Proctor needs to refresh his memory prior to his deposition in not this case. But Miss Reed's attorneys have refused. Argument. Yeah, can you explain to me why we're here? Why aren't you in this? They have not filed this in the state case. He is being deposed in the wrongful death case, and what he hasn't done is filed this, seeking to intervene in the wrongful death case, asking for discovery in that case. Go intervene in the wrongful death case. Go ask the court to allow you to issue a subpoena. Go issue a subpoena to the Norfolk DA's office and see how fast they respond to a discovery request. You worried about that? You worried it's not going to be fast enough? Yeah, I bet. But that's not Karen Reed's problem. That's not her lawyer's problem. You worried that Canton PD is not going to turn over discovery swiftly? Oh no. Argument. Federal Rule of Civil Procedure 26D1 states in relevant part that a party may not seek discovery from any source before the parties have conferred as required by Rule 26F, except when authorized by court order. However, it is also well established that control of discovery is entrusted to the sound discretion of trial courts. Discovery provided to Karen Reed by the Norfolk DA's office is not theirs to give to you. Emily feels very strongly about this. Yes, I have an opinion. Go get a subpoena and subpoena it. This is not the process. Indeed, they say, trial courts enjoy broad discretion in managing the pace of pretrial proceedings, including the timing of discovery. Federal courts will allow parties to conduct expedited discovery in advance of Rule 26F or Rule 16.1 conference where the party establishes good cause. Good cause that you need to refresh your memory for a deposition in another fucking case doesn't count. Unless is there case law? Find me some case law that says that this is a proper procedure. Who thought that filing this motion, you know what? No. Counsel. Hold on. Bring it in. Counsel. This was legally strategic. Law nerds, we're just talking to counsel right now. This was a great idea. I need you to double down. Because frankly, we needed something to laugh at. And this is it hits the spot. And so if you could continue to double down on this argument, the law nerds would appreciate it. Thanks. Okay, good chat. Don't forget to attach the rest of the emails because I bet there's some more and those would be amazing. Okay, cool. Thanks. All right. Good chat. Let's get back to this motion. We're going to not say go subpoena it from the other court. We're going to say just keep doing more of this. This is we love the legal strategy here. This is content Emily is enamored. Lawyer Emily is going to keep screaming and playing the tiny violin, but content Emily is like, yes, more of this, please. Thank you. Appreciate it. The law nerds are just, the law nerds are overwhelmed in awe of your choices. There is a level of resounding befuddlement that is an unusual experience, and we all love to experience new things. So for that, we very much appreciate the choices that have been made here. Yeah. Solid. Well done. Well played. Love. So they go on to say that, that good cause can be established to expedite discovery, and that good cause may be found where the need for expedited discovery in consideration of the administration of justice outweighs the prejudice to the responding party. But you're still making Karen Reed the responding party and not Norfolk. Can you imagine the motions that will come of Proctor fighting the Norfolk DA's office for discovery? Oh boy. The responding party is not the keeper of this discovery, as you said yourself in this motion. See, you said earlier in the motion that you have to have discovery that is in the possession of the Norfolk DA's office, right? It's essential that Proctor be provided access to the documents within the Norfolk DA's office and Canton PD's possession, right? You said it. So go get it from them. Mm-hmm. Okay. So no prejudice to the responding party, assuming that the responding party is the possessor of the discovery, Norfolk DA's office and Canton PD. Great. In this case, good cause exists for this honorable court to issue an order allowing the service of the keepers of records subpoenas. So you are going to go subpoena them? Because Reed's counsel's not, maybe that is what they're asking for. Is that what we're asking for? Maybe it is. Did I miss it? Chat, did they say that that's what they were asking for at the top of this motion? That they were asking for this from Norfolk? Because I read this as that they were asking for it from Karen Reed. Did I miss where they said what they want to do is get a subpoena? Oh, maybe. Specifically, it's right there. I was enjoying the Schadenfreude too much. No, it's up there. I was blinded by the audacity. Proctor seeks leave of the court to serve the attached record keeper's subpoenas to the Norfolk County District Attorney's Office and Canton Police. No, I did. I missed it. Because the rest of it was too ridiculous. Yep. And my brain went to, why are you asking Karen Reed's attorneys for it? Good. That's better. They're telling the court, hey, Your Honor, Karen, well, you still are in the wrong court though, buddy. But I was blinded by the emails. Also, this is what happens when it's a first look. So they are in fact asking for the subpoenas because Karen Reed's lawyers didn't give it to them. They're saying now there's good cause for us to go get it, but you're still in the wrong court. Right. Still the wrong court though. This court doesn't govern that. But he's saying, look, we're going to have to get this discovery from the federal court at some point because we're the defendant here. So can we expedite discovery on Norfolk DA's office and Canton PD? Okay, fair. Let's keep reading. I should have kept reading, but it was too funny. I couldn't. So we'll summarize at the end. It'll make more sense after we are done laughing at, but Miss Reed won't give it to us, because that's honestly where I got stuck with the, but Miss Reed won't give it to us. Okay, so their argument read properly after I've stopped laughing, which, counsel, my apologies. It was up there. The rest of it was just too funny, and I got distracted. The argument to the federal court is, but Your Honor, Miss Reed won't give it to us, so you need to let us expedite discovery on the Canton PD and the Norfolk DA's office. So you need to let us have a subpoena early because this is going to come up in this case. So just let us have a subpoena early. That's a fair argument. The asking Karen Reed's attorneys for it is bold, but they're coming in there saying, look, we tried to go a different way and we can't. And the good cause they are saying is that Proctor is scheduled to be deposed. I don't know if the court's going to find that good cause to accelerate discovery in this case, though. In this case, good cause exists for this court to issue an order allowing the service of the keepers of records subpoenas. First, Proctor is scheduled to be deposed on June 8th in the state court, where he will be subject to examination by plaintiff Karen Reed's counsel. He will also be subject to examination from counsel for at least 3 other parties in that case. Oh boy. Upon information and belief and based upon representations made in open court by the parties in the state case, there are hundreds of thousands of pages of discovery produced by Miss Reed in the state case. But that's to the parties in that case. That's not here. Upon information and belief, included within these documents are police and investigative reports authored by Proctor, other Massachusetts state troopers, and Canton PD. I hear George. They are likely to be trial transcripts from Reed's criminal trials. Well, you can just go watch those on the internet. Hey, George. Hey, T. I hear Georgie. Did you hear George coming in? George is like, it's our cat time. I know. It is our kitty break. Hi, George. Hi, you're drooling. You are just drooling on your boy. How's your day?
Pretty good.
Good.
Yeah.
He's so happy. Good to see you. Glad you're home. We're in our blue code bra mode because people are just bruh. Fair. Bye, George. He's so happy. George is like, it's my boy. It's my boy. I know. George is like the town crier for only Travis. It is I announce the presence of my human, the Travis. All right. So Proctor is worried that he will not be able to remember what he did in this case without the discovery and wants the discovery. There are likely to be trial transcripts from Miss Reed's 2 criminal trials. Your lawyers can order them. Like, you can just go order the trial transcripts from, you might have to fight over getting all of the trial transcripts, but you can go get the trial transcripts. You can go order them from the court reporter yourself. There are likely to be trial transcripts from Miss Reed's 2 criminal trials in the state court, photographs, witness statements, videos, and other evidence that Proctor once had access to. Well, as he is no longer a MSP trooper, Proctor no longer has access to all of these documents and evidence. In order to refresh his memory at this deposition and prepare for his deposition, it is crucial that he be allowed to review these documents prior to his deposition. Deposition. Can we just, why are we asking? Well, keep reading, Emily. Whereas Ms. Reed and her counsel have had access to many of these documents since approximately February or March 2022, no prejudice will result to them. None of the co-defendants will be prejudiced by this allowance of the motion, and none of the co-defendants have waived any objections by the filing of this motion. Proctor respectfully requests this motion be allowed. Okay. The Rule 7.1 certification is the meet and confer. The meet and confer says that Tom, on April 8th, spoke to counsel for the co-defendants and then lists all the counsel about this motion, and all 3 of them informed me that they had no objection to the filing of this motion. I further certify that on April 8th, I spoke and emailed with plaintiff's counsel, Aaron, and he informed me that he would not assent to this motion. Okay. And then we see the exhibity emails that we looked at between the lawyers, where Karen Reed's lawyers were like, good luck. Let's see what Exhibit 2 is. Exhibit 2 is the subpoena that they would like to send. So they are asking that the subpoena be allowed to the keeper of records for the Norfolk County District Attorney's Office, and when and where those records are supposed to be brought forward. There's also a certification that those are the business records, a list of what the records are, same for Canton Police, and same on the certification, same on what's requested. Here's the thing. The fact that Proctor's attorneys went to Karen Reed's attorneys and were like, hey, can you give us the discovery in the civil wrongful death case? That would be great. Karen Reed's attorneys in that hilarious email were like, yeah, no. We have no obligation to give that to you. And we have no obligation to help you prepare for your deposition. And you can go get it elsewhere. And the internet is rife with information about this case. What Proctor's attorneys are asking for, after I went through and reread the motion. Emily, we confuse ourselves sometimes in reading the motions. Yes, I got distracted by the lols in this one. What Proctor's attorneys are asking for, in sum, is to allow or to have the federal court expedite discovery and allow Proctor to use the federal subpoena in the federal case where he's a defendant to go get the case files from the district attorney's office and from Canton PD early before discovery is set in the federal case so that he can have access to it to prepare for his deposition in June. Now, Karen Reed's civil wrongful death case is where this discovery has been propounded. They are not asking for this in the civil wrongful death case as an intervener. So Proctor didn't go to the case where where that's happening and say, hey, I need the discovery to prep for my deposition. Can I have a subpoena to go get it? They went instead to the federal court to ask. And the fact that they thought that Karen Reed's attorneys would be like, oh yes, let us piece through all of our discovery and make sure that you have it. No, they're not obligated to. So could the federal court allow them to subpoena the DA's office and subpoena Canton PD? Maybe, but it would be expediting the discovery. But Karen Reed's attorneys responded yesterday. So we're going to take a look at that. I haven't looked at it yet. Sorry for the confusion I caused when I got confused. So Emily got confused earlier. Go get a subpoena. Girl, we're trying to. That's where we're at. Also, I don't know why we're not in the other case asking for this. I think Proctor's attorneys thought that this was a maybe faster option than trying to intervene in the state action. But it is early to be asking for discovery here. But if this is inevitably going to be discovery, then maybe they're allowed to go get it from the DA's office and from Canton PD. But Karen Reed's attorneys responded yesterday. So that's what we are going to look at next in the federal case is Karen Reed's attorneys objecting to docket 6-7 in docketed item, 68. Yeah. I will take a look before the end of stream to see if there's anything else, but go get it elsewhere. Let's see what their objection is. Shall we? Other than, seriously, bro, what? Opposition to defendant Michael Proctor's motion to conduct limited discovery. The court, here, let's embiggen this a little bit, because eyeballs. The court should deny former trooper Michael Proctor's request to take early discovery in this case for the sole purpose of using it in a separate ongoing proceeding in another case in Massachusetts State Court. Your Honor, they're trying to skip the line. They're trying to skip the line. They don't get to do that. You don't get to skip the line. Go in the other case and ask for it. Proctor seeks to issue federal subpoenas to 2 non-parties prior to the court's Rule 16 conference and before any other party conducts discovery so that he may, in his words, quote, refresh his memory before a deposition in the other case and otherwise prepare for his deposition. And then they cite to where the defense said that. He claims that this somehow constitutes good cause for this court to permit early discovery in this case. I agree with the next part. Proctor does not point to any case, statute, rule, or other authority supporting his request because there is none. Excuse me, Your Honor. They can't do that. There's no, we just don't get to, just do whatever we want. There's, rules. And those federal rules are particularly sticky. So, he fails to state any case, statute, rule, or authority supporting his request because there are none. If Proctor truly believed he had any right as a non-party deponent in a civil case in state superior court to discovery of or access to any of those documents, he would have sought them in such court. Oh, good. I'm not crazy. Good. Okay, good. Right. Why are we in this? Why this court? Why are we asking the federal court to help prepare for a deposition in a different case in the state court? It's such a different situation than the Proctor phone dump situation. The Proctor phone dump situation is protective orders. It's governed by that court. The subpoenas were to the DA's office. It is not the same circumstance here because a subpoena from this court or a subpoena from that court is still a court subpoena to turn over the documents. This is not the only way. So why are we in this court? They go on to say if Proctor truly believed he had any right as a non-party deponent, he would have sought them in such court. Apparently, they say, recognizing he does not, he instead asks this court to assist him in circumventing the state court rules. The court should not do so and should deny Proctor's motion. Oh boy. Excuse me, Your Honor. No, make him go do it in the other court. He doesn't get to do, he doesn't even go here, Your Honor. You don't even go here. Let's see if there's anything that was filed this morning on that case before we go look and see if Proctor filed anything in the state case. We're going to cover the state case tomorrow, but let me go just double check that nothing has happened since we've been streaming. We've been streaming for long enough that shit's possible. Because we've been streaming long enough that that's 100% possible. Can we just be normal, Pacer? Can we just log in? Thank you. Just what are we doing? I have too many cases saved. We'll find it. Where in the world did it go? I just want to double check and see if there's any new filings on this one. Let's see. Why do I not see it? I know it's saved here. There it is. It was hiding. Let's take a look. There are a bunch of other motions in this federal case that we need to get to that we have not gotten to yet. But, oh, that's the wrong docket number. Darn it. Where is the other one? I don't know where it went. All right, it's going to take me a second to pull it up because where I thought it was saved, I have a different suit saved, which is odd. All right, there it is. Sorry, chat. I know. Trying to look for documents in real time is absolutely riveting. I agree. Apologies. Nothing related to this motion that has been filed today. I'm going to take a look at the state court docket too, just to see if anything happened this morning on the state court docket. So let me go double check there, and then I'll just pull the state court docket up as I take a look at the state court docket. Let me just get it pulled up, and then I will put this, as I said, put the state court on docket on screen. It's just going to take me a second to grab it. So no new filings on that yet. I'm sure we will see a reply from Proctor at some point being like, but nuh-uh, Your Honor, you need to let us have it. Please, can we have the discovery? But the boldness to ask Karen Reed's attorneys for their entire file is such a wild choice. It's like, excuse me, are you going to just give us all the discovery or nah? It's we're going to go with nah. we're going to go with no. We don't owe you the discovery. We're not obligated to give you the discovery. And what we're not going to do is give you that discovery. So the choices, I suppose that part of that might be, hey, Your Honor, we did ask in another way and they said no. So because they said no, you have to let us go subpoena it by accelerating the timeline for the subpoenas. Let's see if there's anything here on the docket. Let me pull that up. Give me one sec. Oh, no, there's nothing since April 9th. Okay, well, when we check back in on that docket tomorrow, we'll get there. So there is nothing new on the state docket. So where are we today? Well, Karen Reed's attorneys were actually asked by former Trooper Michael Proctor's attorneys to turn over all of their discovery to Trooper Proctor to refresh his recollection to refresh his recollection prior to his deposition. Here's the quirk on that. He's asking in the federal lawsuit where he's being sued, not the state lawsuit where his deposition is pending. And he is saying to the court that, Your Honor, them not giving it to me is good cause for me to get a federal subpoena to go to the district attorney's office in Norfolk and Canton PD and get their case files. So could you let us just accelerate the discovery so that he can refresh his recollection prior to his deposition in the wrongful death case? And Karen Reed's attorneys responded on April 13th and said, there's not like a mechanism under the law for this to happen, and you should go ask in the state court, which he has not done yet. He has not sought to intervene in the state court asking for the file to prepare for his deposition. There's a lot going on in the state wrongful death case. There is a fight over discovery in that case too. We're going to talk about that tomorrow. But this fight over whether Proctor will get to refresh his recollection, I did not expect that the emails back and forth would be on the level of, you told us that the internet was rife with information, so you could Google it. The brilliance, just the brilliance of the response of like, well, you said we should just go look on the internet, so maybe you should too. Even though, to be fair, Proctor's attorneys weren't exactly saying go look for the information on the internet. They kind of were, but they were also saying we don't want more information on the internet. But they were talking about how much information was on the internet, which led Reed's attorneys to just say, oh, but we agree. This information's on the internet, so I don't know why we should take the time to go through our files and pull out what is attorney-client privileged and what we're not allowed to turn over and what might have a protective order on it. Remember, you're fighting about the protective order in the other case regarding your phone, so we can't even give that to you. So, yeah, no, we're not going to take like all of these, all of the hours that it would take to go through hundreds of thousands of items of discovery to give it to you. You can go get it somewhere else. And if we did and left something out, then it would cause a potential problem in the other case, and we're not going to do that either. So maybe you should go ask the Norfolk DA's office. And that is what Proctor is trying to do, saying to the court in the federal case, hey, Your Honor, we would like to go ask the Norfolk DA's office to give this to us. Even though it's procedurally not the proper time to do that, we would like you to let us skip ahead and go get that discovery. And the court might and say that truly, if this is going to be sought in discovery in the federal case, and it's discovery that Karen Reed already has, and the co-defendants don't oppose it, the federal court might say, yeah, we can issue the two subpoenas, go subpoena them. But the federal court might also say, I'm not ready to be the referee on you fighting to get discovery from Norfolk DAs and from Canton PD. I don't want to referee that discovery fight that's related to another case, because that's not related to our case. And this isn't a discovery fight I want to have to referee yet. So you're not putting this work on my court. We got other shit to do. Go ask the court you're getting deposed in. And the federal court can do that too. They can say this is not our problem, and we're not gonna create a problem that doesn't otherwise exist. So you can go get it elsewhere for now, or you can wait until after our hearings. But there are motions to dismiss pending, and the court's got plenty of work that they need to do on the pending motions. So the federal court could do either, or you know what federal courts are really good at? Federal courts are brilliant at, we don't need to expedite an order on this, and maybe we need to have a hearing on it. So why don't we schedule a hearing? And then by the time the issue's resolved, it's past the time that it's needed. And then the federal court is like, oh, I didn't need to rule. I guess it's moot now because, we're past the date for that deposition. So we'll get to it. It's not that federal courts are particularly speedy in their rulings when they don't need to be. And Karen Reed's attorneys, to their credit, responded incredibly quickly to this. So Karen Reed's attorneys were just like, no, I mean, when did I say that Proctor filed this? Proctor filed this on April 10th. Reed's attorneys responded on April 13th. They didn't drag their heels and wait till the last possible second to respond. They responded pretty quickly. So, it wasn't the ultimate petty. It could have been pettier. It was funny, but they were just like, no, we oppose. Go get it from the other court. And so far, Proctor has not filed for it in the other court, but I'm going to be keeping an eye on that because they might. I'm not sure what the federal court's going to do here, but it's very likely the federal court could let the clock run on this because it's a pretty tight clock between now and Proctor's deposition, which is probably what has Proctor pretty stressed. So what's going to happen with the discovery that Proctor is trying to get from Norfolk DA's office and Canton PD? I guess we'll have to wait and see which court allows him to subpoena the keepers of the records. But that is for another day. I was more amused than I thought I would be by the discovery fights going on here because it seems like it's already going to be 10 out of 10. Tomorrow, and we're going to do questions in just a second, but tomorrow we are going to, I anticipate, unless something else happens that has to be addressed, I anticipate that tomorrow we are going to cover everything that's going on in the Karen Reed civil case, the wrongful death case, the other civil case, because there is a discovery fight brewing there that I am very interested in. And there's going to be some hearings coming up on that I think that we will probably watch together because I'm very interested. There's also a hearing that we have not gotten to watch yet. And there are some rulings we have not gone over yet in that case. So we will be switching to the Karen Reed wrongful death case tomorrow unless something else happens. So with that, let's get to questions. It's going to be incredibly interesting to see where this all ends up, but also the but Your Honor, they won't give it to us. I can't. Come on. Sometimes it takes a minute to reap what you sow, but I'm not going to be mad when we get to watch it in real time because there are things that have happened in this case that are so frustrating, that feel so outside of anybody's control, and that seem to have gone on for so long that looking for a glimmer of karma, professionalism, or comeuppance is something that I'm going to keep looking for in these cases because the behavior is just horrific. And it is staggering that this just seems to be the practice of discovery is ongoing. Can you imagine Lally just writing back to Proctor's attorneys? Discovery is an ongoing obligation. We'll get to it. Get in line. Good luck. Lally. I can imagine that that's what they're concerned about. And maybe that's why they don't want to go to the state court and ask for it. But I am riveted. I hope that you are riveted along with my nerdy what is going to happen now, because I have never quite seen circumstances like these. I've said that every single time we cover stuff going on in the Karen Reed case. I have never quite seen anything like this. And every time we learn more, I am a bit more displeased with everything that's happening, but I am glad that it's coming to light because it should. And we are going to keep talking about it as it comes to light. Sometimes it gets put behind other cases. Civil takes a while, but we will always circle back to it. And I appreciate you guys hanging on when things are not moving as quickly in some cases because we're looking at others. This, I can promise you, will never be a channel where we are just covering one thing unless it is gavel to gavel trial coverage. We are always going to be hopping around covering different cases because ADHD. There will never just be we're all in. If we are in gavel to gavel trial coverage, then that's what we're doing for a period of time. But it will never be, we're just on this one case. We are going to keep jumping around to cases, new things as they come up, things as they resolve, and things post-trial, because A, it's interesting to me to do it that way. B, I'm interested in too many things to just narrow it down. And C, I want to see what's going on all over the place. We are not dedicated to just one case. And there's a lot of things on our docket. And there are some things that we need to just check in on because at least they're not as heavy as some of the others. And honestly, Proctor having to fight for discovery is just, oh no. Oh, that's so sad. Oh no, that must be so difficult for you. I'm heartbroken. Aren't you? Just tear. That must be so frustrating. All right, let's get to some questions. Let's chat. Law nerds, let's just wrap it up. My weather looks like it's going to get a little sketchy. The lighting has changed significantly, not just going to code blue as we've been live. So I imagine that it's going to be our turn sometime soon, and we're going to need to be mindful of that. How have we been streaming for almost 4 hours? It's going to be a shorter show today. I didn't even grab nearly as much. Never a chance. Never a chance. And again, a huge thank you to our sponsor, Incogni. Incogni, thank you for letting us talk about things like the FBI getting hacked in their wiretapping unit. Wild stuff. And reminding everybody that your information is going to end up on the internet one way or the other, and Incogni will get it back off the internet. Lots of you are saying that Ryan Hall is already live. Well, that's telling. Look, I will say this every single time. Our streams will always be up on replay. Occasionally that takes us longer than others, depending if we get into trouble with the copyright powers that be. But if you are being discussed by anyone that is talking about severe weather, go do that first and then come back. That's more urgent. We will be here. Go do that and then come back. Always. Because we will be back. So stay safe. Take care. I know that it's spring, right? It's spring. And this is one of the things that happens in the spring, depending on where you live. To all of our members, thank you to everyone who gifted memberships today. Thank you. GM said, wow, I love this news. I've been a member for months, 38 months. That's not just a few months. That's all the months. And I love that you guys are enjoying the way that we changed our membership badges. They are a lot of fun. Hunk Banana No said, it's not a wicked pissa. It just is wicked pissa. Okay. Or even just pissa. It depends. Fair enough. And I appreciate it. Kate History Mysteries says 2 years as a member. Hi from the Kates in Liverpool. Good to see you. And good to see all of our members. So Celtic Moon said, just found out I have ADHD. This makes so much sense. A lot of you have walked your ADHD journey along with the Law Nerds. It's just, there is something that is very helpful when someone looks at you and is like, this is how your brain works. And you're like, oh, it's not just me. Yeah, it's not just you. ADHD is a weird quirkiness of the brain, and it can be very frustrating where you're like, okay, but I can do all of this in the world, but like registering my car on time is like a no for me, dog. Like they don't let me just set it on like auto, which is so annoying. It's like, can I just auto renew? Yes. Here, my number one ADHD tip is just anything that needs to be paid regularly. If you can put it on automatic payment, put it on automatic payment. Even if it's the minimum payment, you go in and pay more so you don't miss a minimum payment. Automatic payment is a game changer, and go from there and don't beat yourself up. And there are things that are just harder to initiate. It just is. Sometimes making a playlist helps. So sometimes it's like, I have to do this thing I don't want to do. Look, I have a 50-hour Sarah Boone video. Put it on. I got you for, the entirety of what you need to do. Sometimes a new playlist is what you need. It is not procrastinating if you need to sit down and make a playlist before you get work done. It is not procrastinating if you need to clean all of the shit off your desk before you start a new task. Sometimes you just need to clear the runway to get things done. That is not procrastinating. Do not beat yourself up. If you need to kind of reset the space and the vibes to get the things done, it's part of what you need. It's okay. Do not beat yourself up about it. It's all right. Give yourself the time you need and you will get it. It's fine. Yes. It's fine. All right. It is not procrastinating. It is preparation. You know how when you are doing the things you need to do, there is prep work for, like, I don't know, depending on where you live, you need to warm your car up in the winter before you go drive. You don't look at your car and be like, why are you procrastinating? Before you're like ready to drive your car, shouldn't you just be ready to drive? No, sometimes it needs to warm up before you can drive it, or you're going to fuck it up. Your brain is kind of the same way. Sometimes it needs to warm up before you can drive it, or it's going to fuck shit up and it's just going to make it harder. You just have to figure out what that is. Nobody is going, pick band artists that you love. No one is going on stage cold. Everyone is going to warm up. They are going to do a sound check before they perform. They're not just going to walk in and walk onto stage and perform. They're going to do all the things they need to do to warm up their vocals and get ready and prep their instruments and, lube the trumpet or whatever it is. It's the same with ADHD. You just need to recognize those things as part of your prep work or your warm up before you do the thing. It's not procrastination. It is a warm up before you do the thing. The next part of that is making sure no one interrupts you while you're doing that warm up. Because if they interrupt you while they are doing the warm up, it is going to throw it all to the side. So good luck with that. You got to find what the warm up is for you. But it is part of your checks. It's part of your, pre-task checks. All right, good. We're good? Yes. We're good. No. Shar, lube the trumpet is not a euphemism. They need to be taken care of or they get sticky. The trumpets get sticky if you do not take care of it's actually true. And when they're sticky, it makes everything harder. And if you are trying to play a trumpet and your keys are sticky, it's going to make all of it fucking worse. And then you're going to have a miserable performance and you're going to be like, fuck, this is the worst ever. Your instrument's just not prepared right. It's not you. You got to do your prep. You got to do your prep. Gotta make sure that valves. Yes, that same thing. I'm not a trumpet player, but yes, those. Travis actually helps Griffin take care of his trumpet, but the sticky keys are just a problem. They're a problem. So you've got to just do the groundwork to then do the thing. That's all. Those are my top 2 tips. Who was noising? Hi, Trav. What's up? What do you need? Nothing. I just heard noise outside my office.
I just heard my name a couple times.
Oh, I was talking about Griffin's trumpet. Thank you, buddy. I appreciate it. George, what are you doing? Everybody's doing things. Anyway, those are my tips. It's hard when you think of it as procrastination because it makes you feel like you're doing something wrong. That's gonna, oh, the blue jay is outside. We have a very sassy blue jay, as they tend to be. So George is watching the blue jay and the other birds try to figure out what they're doing. So George is staying with me for a minute. But when we view things as procrastination, or if people in our lives told us that we were procrastinating and made us feel some kind of a way about it, it can block us getting the things we are getting done. It's okay to be like, I need to do the things that I need to do. Perfect. It's perfect. You just got to change the language on it and let yourself go through your process and try to understand what your process is. That's all. It's just part of the process. Aussie Stitches said, I have a sassy cardinal. I named him Jeffrey. I love it. We have some sassy cardinals too, but the blue jay, we also have a pretty sassy redheaded woodpecker, but it makes it funny. It does make it funny. So hopefully the ADHD inspo is just a reset. Crazy Cat Queen said, what about sitting and staring off into space? I see that as a mental reset. Sometimes you got to clear the runway physically. Sometimes you just need to clear the runway where you're just resetting yourself to move into the next task. That's just transition time. And that is valuable too. You cannot go from thing to thing to thing to thing to thing if you're not highly motivated to. Now, if everything you're doing is fun, it's real easy. But if things are a little more challenging, sometimes you need to just reset your system. And that's valuable time too, to just reset. That's it. That's all. It's good. It's good. Let's see. Tiffany, speaking of ADHD, Tiffany said, I used your operating system analogy when explaining ADHD to a parent of a therapy client. The mom, oh, you're going to make me cry. The mom started sobbing. It was the first time it made sense to her. I'm so happy. That makes me so happy. Tiffany, I'm so glad. It's why we talk about it. Because sometimes you just need it explained to you a different way. And the way that we can express these things in different ways is really important, because a lot of language around ADHD can be that there is something like wrong. And if we treat it like it's something wrong, then we treat it like it's something that can fix. And it's not. It's just what it is. There's nothing to be fixed. There's nothing that even should be fixed. But we have to look at what is and then work with what is the same way we would work with anything. Like, this is what is, and I got to work within what is. And so the operating systems are just, we operate differently. And when we operate differently, if we expect, a Mac to operate like a Windows machine, and you're staring at your Mac going, why aren't you a fucking Windows machine? Why don't you work the way a Windows machine works? The Mac is like, excuse me, I'm a Mac? So you're trying to do the wrong things. I don't work that way. And that's the same for those that are ADHD. It's like, I don't work that way. Like, that might work for you. I don't work that way. So wrong input, wrong output. That's it. Cheryl Ray said, why can't we all be Linux? I mean, I'm sure some of us are. But again, trying to get Linux to operate like Windows is still not going to work. And that's okay. But we just don't talk about it that way. We talk about it like, oh, everybody should be able to do this way. No, we don't. The Mateo guy in the chat said, Mac? I ain't no Mac. I'm a Peterbilt. Yep. Exactly. All right. I'm going through statements to find questions and making sure that we're finding questions. Squeaky Ghost said, was driving when you said proctory problems. And my thoughts went straight to, those usually require a proctologist, which he will probably need at the end of all of this. It might, a deposition might feel that way, especially if Alan Jackson is doing the deposition. EDB funny, we were talking about Karen Reed today. I've been going back through the retrial, and I am currently at Burgess Redirect. Alessi is great. Alessi is great. Tracy from PA said, are you going to talk about Tully? We definitely talked about Tully. We might have more Tully conversations tomorrow when we talk about discovery, but I'm not sure yet. Kerrigan, we are going to do a super cut of Depp Heard. There is just some testimony missing that I have not been able to do. We are going to do some members only where we cover things that are not, that are days I was traveling during early on of Depp Heard, and then we'll super cut it together. But we will at some point. Let's see. Kare said, OPP, our pal Proctor is continuing to be an embarrassment, an amusement. And I'm here for the amusement. I am here for the what the fuck is happening? What the fuck? I'm here for it. I'm not mad at the what the fuck. At least we see it in the motions. Look, we're getting to watch the lawyers all lawyer, and we know there is so much background, and we've seen so much of it play out. We're not just jumping into a civil case where we don't know what's been going on. We've been watching what's going on between these parties for years at this point. So that amount of context with the two trials makes the email of just like, oh yeah, no, we're not doing that, so much funnier. Just so much funnier for all of us. Let's see. The Stash Down Diaries, I think I got that right, says 10 years, 11 months, 17 days left for this public servant. Exactly my point. Exactly my point. Pookie said, I'm over Karen Reed. I don't know if that's Karen Reed or Kouri Richins. We did 2 KRs today. Pookie, I don't know which one. And apologies, we're going to be covering both of them for a little while longer for sure. It's going to take some time before we get to the end of that. June in the chat said, which state takes priority for sentencing in a case where a defendant is serving a life sentence in California and was later tried in Florida and sentenced to death? Which state takes priority in carrying out the sentence first? I would need to take a look at the specific case, June. It's a hypothetical that I have not contemplated on priority, but I would need to take a look. I do not know, and I have not looked since, probably the early 2010s. So the knowledge that I do have is also probably out of date. So I imagine that would set up for a legal argument between the two states on how they take priority and if it's the first state or not. So I would have to take a look. But if there's a specific case, then that would be where to start, because there would probably be motions filed in that. So off the top of my head, I cannot help very well without a little bit of research. So damn in the chat. I'm not going to, 1973. I'm not going to be able to get it right. D1973. Getting my Yachtly Crew tickets now. Have the best time. You know, I love a Yachtly Crew show. It is the best. Susan was talking about eyes to the sky. Yes. Prepared, not scared. Find your favorite weather nerd and follow them and the Storm Chasers. There was quite a lot going on Ryan Hall's stream last night. There was some incredible lightning. I think it was in Kansas City. Just some crazy lightning last night. All the Storm Chasers were out. It was some wild weather. So of course it is time to stay prepared if you live in an area. But if you live in an area where the weather gets weathery, you know if the weather gets weathery. Stumbling through to, thank you for the super chat and the kind words. It's been a long time since the Tati Westbrook cases. We have covered a lot of different things on the channel, and they're not going to stop. There are new cases happening, and I'm just like, what are we going to get to next? Because there's new stuff we need to put on the docket. But some of that is going to be timing. And when we jump into a case, it's a little further along. When we jump into a case that's closer to trial, and just trying to space those out based on interest, and your interest, my interest, and time. Because I'm looking forward to some sentencings coming up. That sounds terrible, but I am ready to put the Banfield case under the prison is where I'm at on that. And I'm really interested to see what Judge A has to say at sentencing. Like, I am I am ready. I want to see what Judge A has to say at sentencing for Banfield. And I'm curious about what's going to happen with Kouri Richins' sentencing, though I think it is most likely that it will get put over. It's the first setting. Counsel has reasons. It just is. Let me refresh and see if there's any new filing there before we wrap up for today, before I go and prep for tomorrow and make sure that I get some of the administrative work that I need to get done so that Team Baker is not ready to throttle me and be like, girl, you've got to finish your admin work. There's admin work that must be done. Let's take a look at that docket real quick. This is our final look at the Richins docket to see if there was anything else today, because I'm curious. And then, well, we'll see if anything happens between now and tomorrow's stream, but I anticipate covering the civil case in the wrongful death case. All right. I'm just waiting for that docket to pull up because it's taking a minute. Views Through a Lens said, can they invert all the documents and send them to him and make Proctor uninvert them? They can't really fuck with the discovery. I mean, Karen Reed's people are just not going to send it, but they can send it in the format that it's in. I mean, they don't have to they can send it in the format that it's in. They can't mess with it, which would be a problem. So they can't do that. Let's see. I'm just going to answer some. I have not seen this. Big Sister, EDB, are you going to cover the Love is Blind attempted murder case? I haven't seen that. But it's not helpful in the pop culture docket when it's all also murder, but I will take a look. There's a couple cases that have been popping up that I am interested in. There's been a lot going on. Auntie Ray said, thank you for 10 months of knowledge, fun, and DCI. We love it. Again, I know. Emily, Winter Guard season literally just ended. They aren't even done with, indoor perk. I know, but I'm ready. Ready, not ready, all of the things. Because it feels like as we're talking about sentencing dates into June, it feels like we're already there, doesn't it? Oh my God, this docket is so long at this point. Nothing new on the Richins docket just yet. If anything pops up today, because I'm going to be checking again. If anything pops up today, I'll let you know in the Lawnerd app. Make sure you have the Lawnerd app so that you stay in the loop with what we're doing. And most importantly, when we are getting ready to go live. So for those of you who are just like, Emily, when do the lights dim to actually take your seats? Don't worry. That's when the Lawnerd app lets you know. We're getting ready when A, the chat opens up for members only, and B, you get the Lawnerd alert on your app. It's when our lights dim, now it's time to take your seats. We give everybody a minute to get in, myself included, and then we go from there. Derangement asked about the Courtney Clenny case. That just got continued, didn't it? So it just got continued out. So I don't know the case well enough to know if and how that will stream. I haven't looked at it close enough. I did see that it got continued. So it's going to be a minute because the trial just got continued. A couple trials just got continued. So it'll be all good. Lawnerds, thank you. I saw Casey Cat said, yep, it was plumb wild here in Kansas City last night. And part 2 is about to open any minute now. Well, that is a perfect time for y'all to stay safe, take care of yourselves, take care of your paw nerds, take care of the spinny weather. And for those of you that had never heard of the Sarah Boone case prior to stream today, enjoy that rabbit hole. And don't worry, I will be back tomorrow. I will see you then. Lawnerds, take care of yourself. And I will see you soon. Thank you, Team Baker. All right. Go forth, be productive. I'll see you tomorrow. We'll get stuff done. I will let you know tomorrow if I get my laundry done. It is my goal for today. I got to do some laundry. I will see you tomorrow. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here and thanks for being a Lawnerd.